your Lordship's permission to mention. This is item 31, which is on your Lordship's board today. It had last appeared last week. I was present before your Lordship's another bench. But I was given liberty to mention subject to your Lordship's convenience.
Item 31.
31. It would be taken up subject to your Lordship's pleasure and convenience.
Today.
Grateful. Today.
What is the matter about?
Well, the matter is about, these are petitioners about 609 in number who underwent a full course, my lord, and obtained diploma in rural health and medicine, my lord, by under a state statute which has later been struck down, my lord. And there are directions which are contained in the judgment of the Honorable Supreme Court, which in our humble submission permits them to continue to practice allopathy medicine in the same manner in which they were practicing under the Assam Act. So that's our submission. So
now
the prayer is for a writ. The pleadings are complete.
It was
admitted.
Couple of partnered matters.
Yes,
including one series. So it is subject to.
Yes, my lord. I did, my lord, also inquire from Mr. K. N. Chaudhary. I had an occasion, my lord, long back to appear along with him, my lord.
Right.
I inquired, my lord. I was told items 2 and 3 is parted before your lord.
There's a series also.
Yes, my lord. Subject, of course, to that, my lord.
Or if you want, we can give you another date.
My lord, it will be too taxing for the petitioners, my lord, to get me here again. I'll wait, my lord, my turn, my lord.
Right.
Subject to whenever your lordships find it convenient, my lord, I'll be very obliged. I'll wait.
Yeah.
I'm very grateful.
May I please, Your Lordship? With the consent of the petitioner's side, I'd like to mention item number 5. Today I have some little difficulties, my lord. Not today. A request has been made by Ms. M. B. Bhuya. List this matter after vacation. After 15th of July.
Item 5.
Item 5.
You are for the
I am for the respondent and
respondent. The request made by the counsel for the respondent of the matter, and with the consent of the counsel for the it is said it will have to be in July, end of July.
Well, obliged, fine.
May please, Your Lordship. Actually, with the due consent of the other side, I would like to mention item number 7 of today's daily list. Actually, we have some personal difficulty today, my lord. Can this matter be taken up after 2 weeks, my lord?
Yeah. It would be too much. Next week, any fixed court date.
What difficulty have you got?
Today, my lord, some personal difficulty, my lord. I'm being led by.
If there's an objection, we are not adjourning it.
My lord,
short date.
Short date he's asking.
There's no short date because we are next couple of weeks will be overburdened.
2 weeks, my
So
lord.
it has to be in July.
My lord.
If you agree for an adjournment, it goes to July.
My lord, July. I'm agreeable.
Item 7, the
Good,
joint request made by the counsel for the respondent and with the consent of the counsel for the petitioners and referred to be listed in the 4th week of July.
My lord. Deeply agreed.
So item 8 to 26, my lord. Yesterday I received, my lord, 2 affidavit in opposition, my lord, filed by the SLRC and the personal defense. I have to, my lord, file reply only 1 week, my lord.
I filed the affidavit on behalf of respondent number 2, the personal department, who has issued the OM which is impugned in the entire series.
And also only SLRC has been filed. In
All the
item,
matters.
my lord.
This affidavit will cover
It
all
will
the
cover all. Same OM has been put together.
My lord, if your lordship, on 17, my lord.
Yes.
17, no?
June.
Or immediately after reopening.
The matters, once we begin the hearing, you should complete the pleadings and we'll hear complete the matter. What is the fun in giving it parted? Then why did you file the affidavit yesterday when you know the matter is fixed today?
Got the information. The additional affidavit.
Item, what is that? Item 8 onwards.
8 to 26.
8 to 26.
Right.
The request made by the counsel to the commissioner has filed a reply affidavit, rejoined the affidavit. The affidavit filed with the respondent. July. End of July.
July,
End of July.
apply.
Please, your lordship. Lordship, with due consent of the other side, I beg to mention item number 6, lordship.
Yes.
And this matter may be fixed after vacation, lordship.
Item 6 to be listed after 4 weeks at the request of counsel for
Petitioner, lordship. This, sir.
after 4 weeks. Yes.
Highly obliged.
May please, your lordship. This is also regarding non-payment of pensionary benefit loss. Notice was issued long back in February loss. So as on today also they have not filed any affidavit.
Yes.
Basically also he was engaged as a casual employee lawsuit and he has rendered continuous service of more than lawsuit, that is 7 years. In between lawsuit, during his service he died.
Lordship, we have received the instruction. Lordship, kindly allow me 1 week time so that we can file the affidavit. Lordship.
You have received instruction.
Lordship.
The legal data for the petitioner and the particular and the additional sitting of the response. Submit that instruction by giving it to the court by way of affidavit. Let her file an
No.
affidavit.
Obliged, Lordship.
Apply.
Your Lordship, I make a spurious note here.
So what do you say with regard to the, he is referred to some judgments.
Okay, Your Lordship. I have filed an additional affidavit, Your Lord.
You have filed.
So my submission is first that
So how do you respond to the delay?
no delay. I'm reading the. Please come, Lord. I would request to come to the
Affidavit,
submission I made in the
Affidavit.
additional affidavit
additional.
from 32 to 30.
Date of September. 30 September.
No, lot of new affidavit, additional affidavit.
2nd June. Yes.
Yes. Page number 32, where I have made some submission. So I am reading it, Your Lordship. It is submitted that the limitation issue of above petition was noticed by the Honorable High Court in the first hearing of the case. After that, the judgment of linked case of so was submitted through additional affidavit, in which it is clearly stated that the said writ petition is being withdrawn to approach the respondent to avail arbitration clauses in the contract agreement. After which the petition was not considered time barred and hence allowed. And that is the first point. Now coming to the second point, Your Lordship. It is submitted that the condition 70 of IF 2249 per para 3 clearly state, the copy is enclosed, Your Lordship.
Yes. Ego boy. Raise it. Good.
Your Lordship, condition 70, the page is enclosed 40. It, in the event of abandonment of the work or cancellation of the
You're reading
contract,
from? You're reading from?
page second submission, Your Lordship, page 33 of my condition. It is submitted that condition 70 of IF 2249 para 3 clearly state in the event of abandonment of the work or cancellation of the contract under condition 52, 53, and 54 thereof. Such reference shall not take place until alternative arrangement have been finalized by the government to get the work completed by or through any other contractor or agency. In this instant case, the respondent authorities issued notice on 14/9/2021. As per the contract condition, the reference starts from 14/9/21 only, and the condition 70, page 40 is enclosed, your lordship. 2249, condition 70. Para 2. And the interim order of the Honorable High Court is also enclosed, which says that the notice was issued on this date, 14/9/2021. So under this also, it doesn't come under the
What
limitation.
do you say with the regard to the judgment?
That was interim order was issued, your lordship, for the alleged recovery, and that judgment has been enclosed in this one. 37 to 38. And the date is, the respondent authorities via a communication letter 14/9/21, annexure 1 to this, has informed the petitioner that the balance part of the contract have been awarded at this one. So from this point of view also, that date of reference start from 14/9/2021. So from this condition also, this
Why
petition
don't
doesn't
we-
come under petition limitation act.
Refer the matter, let the arbitrator decide on this issue.
Your Lord. And third, your look, now I'm coming to the judgment. The
But otherwise, Lordship, there is no legally issued notice, Lordship, because he was unauthorized at that time.
And-
Under section 21, Lordship, arbitration proceeding starts from issuance of notice under section 21. And he was not authorized at that time to issue notice.
it was a mistake of 2 days only, your
No,
Lord. I have
Lordship,
already
this-
submitted.
This was issued on 14/2/24, and he was, power of attorney was issued on his behalf, Lordship, on 5/3/24, after 1 month, Lordship.
Your Lordship, I have, in additional affidavit, I have submitted the authority letter issued in their letter pad, and there was only 2 days mistake. I wrote the letter on 14/2/2024, and by mistake, he wrote the letter 16/2/2024, that I have submitted in the additional affidavit. In reply,
Power of attorney,
Now, what is your objection to the appointment of an arbitrator? There is some dispute. Dispute has arisen. We may permit him to issue a fresh notice and call upon you to appoint an arbitrator.
that even also limitation will attract, Lordship, because till that no legally issued notice is exists, Lordship.
in your Lordship, now I'm coming to the judgments submitted by this amicus curiae.
Where
Amicus
is the
curiae.
amicus? Where is the amicus?
I will request to come to page 50, para 51 of this judgment.
Para 51 of
Judgment of BSNL and Norton. Last page, your Lord. And bottom. 51. And it clearly says there must be clear notice invoking arbitration, setting out particular dispute, including claims oblique amount, which must be received by the other party within a period of 3 years from the rejection of a final bill, failing which the time bar would prevail. And in this case, your Lordship, the department has informed us that they have prepared a final bill on, your Lordship, 30, just a minute, your Lordship, in additional affidavit. In my additional affidavit, page 42, your Lordship, now submitted. Page 41, your Lordship. They have informed us on 30 April 2024. And second paragraph, Your Lordship, it is intimated that the final bill of the completed portion, so it is not our claim, it is the admitted amount. Completed portion of the work has been prepared in the Office of the Engineer in Charge, AGNM, date to 30 April 2024. Even in that case, and we have not accepted it because we have already filed an arbitration petition and 2 hearing was held before that. So in this case, the limitation never starts. It is still up to 27, even if we count the supplementary judgment only. It will go up to 27. And Your Lordship, my last submission, because I am requesting the Honorable Court to dismiss the writ petition signed by the opposition, in opposition by the person, because the writ petition was signed by G. Garrison Engineer. And as per Arbitration Act, General Provision GH, party means a party to an arbitration agreement. And this in this contract, G is not a party to the arbitration agreement. So this writ petition filed in opposition is liable to be dismissed. He has no power to sign any affidavit.
Which writ petition?
The writ petition, the affidavit filed in opposition by the Union of India. And even this, they have did it against the policy letter issued by the department itself.
All right, we'll take it up after a while. Let the amicus come. Inform him. If he is not interested, we'll remove him and get somebody else. When the matter is clicked, it would be available. Wait for some time.
Okay.
Phone করে বলে vote you. If you're not interested, we'll change it. Yes.
The Lordship. Lordship, the learned advocate general will appear in this matter. He's on legs in port number 2. He'll be here shortly, Lordship.
He's completed his argument? No.
No, Lordship. He has to add something to it, Lordship.
So there are other matters we'll have to proceed with. We can't keep on shifting matters like this.
Lordship will be here shortly, Lordship. It's a very short matter in court number 2, Lordship. It has already started, Lordship.
This is the partner matter.
This
This is the partner matter.
Lordship, that matter has already started, Lordship. He'll be here in 5 minutes, Lordship. The matter is going to end then. Lordship, today, Lordship.
Next.
record to please.
Yes.
Lordship, on last opinion, records are called for. It has not yet arrived, Your Lordship. Even on 22nd of May only, I received a letter from the Assam Police Headquarters requesting the Home Department to transmit the records to me so that I can produce it before Your Lordship. But I have not received it, Your Lordship. There was the allegation which the petitioner has raised basically was with regards because the examination records was necessary because he had actually alleged that the cross-examination of the witnesses were not made available to the petitioner as well as assistance of a defense assistant. And we in our affidavit has categorically stated that he was provided all opportunity to cross-examine the witnesses.
If your records are not here, what can be done?
That's what, Your Lordship, that's why.
What can be done?
Records, Your Lordship, some time.
It is
we
for
can
you
take.
to
Just,
ensure that your records are in
just-
time before the court.
I understand, Your Lordship, just
Yes.
1 week time may be granted, Your Lordship.
1 week time.
Just 1 week time, last opportunity, Your Lordship.
Why the records are not available?
I don't understand, Your Lordship, it is not reflecting the letter,
Yes.
Your
If
Lordship.
it is not reflected, we proceed with the hearing. You are not, we'll take it that you are not interested with the in production of the record.
Lordship,
Whatever
is
is
the last
available in the
opportunity.
pleadings, we'll go ahead.
The last opportunity, Your Lordship, I'll get the record, Your Lordship. Just 1 week time, Your Lordship. Next Thursday, Your Lordship, I'll get it. Your Lordship.
You don't get to fix the boards of the court, or the calendar of the court.
I
There are
apologize
matters
for
fixed.
that. I apologize,
We
Your
had
Lordship.
fixed it for production of the record. Yes, Mr. Bhattaji.
Without record, it will be difficult for your lordship to arrive at the judge conclusion.
We thought you'd be ready to argue the
I
matter
am
without.
ready, man. I am ready. If you lordship, the other matter, I am ready.
What is the stand in the affidavit?
In the affidavit, Your Lordship, at paragraph number 9, specifically with regards to that cross-examination of the prosecution witness regarding that allegation in reply to paragraph number 13.
In fact, there is no reply, my lord. In respect of para number, lordship may kindly see their affidavit, para 10, my lord. Good. Para 10, my lord, their reply. So for the paragraph of 14, my lord. The 14, paragraph 14 of
What
the
is the
repetition.
punishment imposed?
1 increment, my lord. Suppose of 1 increment for 1 year with cumulative. This is a very minor banishment.
Then?
Hello? So many infirmities is there, man.
What about the appellate authority?
The appellate authority have to dispose the matter within 3 months, my lord.
Hmm.
It is now 6 years, 7 years passed by now.
It's still pending before the appellate authority.
Still pending before the authority. They did not have, even after the instruction of the court on the number of occasions, my lord, they have not taken up the appeal, my lord. So it is after it is 2018 matter, my lord. Now it is not.
Why? What is wrong with the appellate authority? Is it there or some orders have been passed?
That is what we had also written
Who
to
is the person responsible here?
the Additional Director General of Police. Your Lordship,
Please call
SPF.
him. We'll call him to court. Who is he? Why these instructions are not forthcoming? Who is the Additional Director General of Police?
I have to find out, Your Lordship.
That also you don't know.
Lordship.
You call your senior government advocate. Please call for the senior government advocate. We'll call up afterwards.
Yeah, please, Your Lordship. This matter is relating to selection and appointment of rehabilitation worker on contract basis, Lordship. Lord, the selection process was carried out.
It is for what?
Selection and appointment of rehabilitation worker under NASN. My lord,
Worker.
selection process was carried out. After publishing the final result, the selection process has abandoned, cancelled. My lord, in fact, Lordship, some other category of post, they have already been filled up. If your Lordship kindly come to page 42, this is the advertisement. And 43 is the serial number 9, rehabilitation workers. Total number of posts is 54. And altogether, Lordship, 51 category of posts were advertised by this advertisement dated 30/7/2022. Lordship, thereafter, Lordship, interview was taken. After that, Lordship, the selection list was published. That is, Lordship, page 63.
You had applied for which post?
Rehabilitation worker, Lordship, page 43, serial number 9.
All right, then what happened?
Lordship, selection list that your Lordship will find page 63. Name of all the petitioner, Lordship, as reflected in the select list. After this select list was published, Lordship, on 13/3/2024. Thereafter, Lordship, parliamentary election was held, Lordship, for which some time was taken. Subsequently, Lordship, the MP notice, Lordship, page, Lordship, 67.
No, in the selection list, your name is not there.
All the petitioner names are there.
There. Then
After that, Lordship, all the selection process has cancelled. Page 67 is the MP notice, Lordship.
then
Lordship got it. It is for information of all concerned that for some unavoidable circumstances, following advertisement already published for filling up of vacancies of various positions under NHM Assam are hereby cancelled in respect of the position for which recruitment are yet to be done. That is, interview already conducted, but results are yet to be declared. Result already published, but postings are yet to be done. Interview yet to be conducted. Our case, Lordship, result already published, but postings are yet to be done. And our advertisement, your Lordship, will find in just 4th line. NHM 310131148 2018 HRD so and so, dated 30/7/2022. This is our advertisement, Lordship, page 42. This advertisement has already been cancelled. And paragraph in serial number 8, your Lordship will find in the MP notice, page 67. So and so NHM, he is requested to upload this notice in NHM website and arrange receipt of online application. They will try to conduct, Lordship, fresh recruitment process. My Lord, that process has already been stated by this honorable court, directing not to fill up the post without the leave of this court. My Lord, now in the MP notice, Lordship, there is no reason as to why they have cancelled this selection process.
what
In
is there
fact,
said in the affidavit?
Lordship,
What is there in the affidavit?
yes. Affidavit in paragraph, Lordship, 5 and 6. They are saying that the reservation policy is to be followed. Page 5, Lordship, 99, running page, paragraph 5 and 6.
Yeah.
May I read, Lord? That with regard to the statement made in paragraph 7 of the requisition, the deponent beg to state that as per decision of the state government, after due consideration, it has been decided to provide reservation in respect of appointment to the services and post during direct recruitment under National Health Mission Assam from now onward, as per government rules. That as regard the statement made in paragraph 8 of the requisition, the deponent begs to state that since its inception, your Lordship, kindly see this sentence. Since inception, National Health Mission Assam is following the prevalent practice of contractual engagement in vice doctor, paramedical staff, and program management staff. Regarding reservation during recruitment, till date, National Health Mission Assam is not following any reservation norms except reservation for persons with disability candidates. Prior to that, Lordship, their own admission that no reservation policy was followed. As such, for implementing the
Where have they stated no reservation policy followed? Where is it stated no reservation policy is followed?
my lord,
Where has the NHM stated that no reservation policy was followed in the advertisement or selection?
my lord, their statement is that prior to this selection
No,
process,
that is in the affidavit. But while cancelling the advertisement or the selection process,
only for unavoidable circumstances, there was no such page 67.
no, you showed somewhere that it is because of reservation policies not being followed.
No, that was the standard in the affidavit. In the impugn notice, Lordship, only unavoidable circumstances.
All right.
This is the only reason. And my lord, para page 99, I'm continuing from last line. As such, for implementing the reservation norms under NHM, Assam, a process has already been initiated, and accordingly, all the ongoing recruitment advertisement have been cancelled. Notice so and so dated refer including the selection of the candidate against position of rehabilitation worker. Now, Lordship, this 7 is also important. As regarding the statement made in paragraph 9 and 10, the deponent vexed the process of recruitment of the petitioner was not completed at the time of cancellation of selection. Although they were selected for the position of rehabilitation worker, but not appointed in service under NHM Assam, and no order selection letter was issued to anyone. Regarding few other positions, your Lordship will see. As mentioned in the writ petition, which were already filled up by the authority, engagement orders were issued for all those positions from NHM authority, showing place of posting. Both the categories are different and there was no discrimination. My lord, if your Lordship kindly come to page 42 in my writ petition, your Lordship will find this is the advertisement altogether. 51 categories of posts were advertised. And out of these 51 categories, 8 categories of post, Lordship, serial number 1, dental surgeon. These posts have already been filled up. Page 78 is the order of posting. Regarding dental surgeon, page 78 is the order of posting.
Yeah.
Next, serial number 6, Lordship, laboratory technician. They have been appointed. Page 69. 69 is their engagement order. Thereafter, Lordship, serial number 12, counselors. 82 is their posting order. Page 82. Now, serial number 20, hospital administrator.
So you have decided to implement reservation from this year, from the year under consideration.
Yes.
Where
Yes,
is is it available in your record somewhere that you have taken a decision before cancellation?
No, no record in this. My lord. In this case, my lord, Mr. Bigoba will appear, my lord.
So if he appears, please call him.
Yes, my lord.
Please call him.
Yes,
On the same day, 2 select list was published. One has already been appointed, and only the petitioner, rehabilitation workers, their selection process has been cancelled. I have annexed all the 8 categories of posts they have filled up. This is a clear discrimination, Lordship, on the part of the respondent.
Discrimination.
Discrimination
In
as
respect to whom?
as well as the lordship, the petitioner lordship has duly selected. Lordship, there was no any allegation of any anomalies in the selection process.
Are you making any allegation against any officer, any private respondent, that in order to accommodate them, your selection was cancelled?
No, nothing, lordship, they have mentioned or stated anywhere that
Yes, madam. But you are here, your affidavit is there, your affidavit says that you suddenly decided to follow reservation after the selection is over, after the select list is published. Why did you wait?
Decision of the government, my
No, decision of the government is all right, but you
during
must
the
have some rationale. Mr. Gogoi, why did you suddenly decide to follow the reservation after the selection is over, names are published?
My lord, so far as my lord, this present category is concerned regarding the petitioner selection, entire select list, my lord, nobody was appointed.
No, that is
Few,
okay.
my lord,
They
yes.
have an expectation that having appeared, their names being published, they're waiting for their appointment.
Lordship. In fact, my lord, so far as my lord, the posts that were not filled up of that particular category, because there were several posts were advertised. So those posts, my lord, are all cancelled, my lord, and accordingly, it was decided that, my lord, the reservation will be applied in full. So fresh advertisement will be. That was the decision. My lord. Otherwise, also, my lord, going by, my lord, the provision of law, my lord, a selected candidate, even though his name appears in a select list, does not, my lord, confer any right. Otherwise, my lord, yes.
It's all right, but you have to explain contact. Why
Yes, yes,
suddenly
of course.
After selection, the names are published, you decide that reservation is applied.
It will,
We rightly apply.
yes.
Why? After the selection is over, who is taking the decision? Where is that order in the file?
My lord. Then lordship will have to, my lord, record will speak for my lord. Because affidavit says, my lord, they are only on simple reason. So when the decision, how it,
Who is responsible for calling for the selection, verifying that there is no
my lord, admittedly, the advertisement was issued by the National Health Mission. In between, probably, my lord, there was change of policy. And sport they thought, because, my lord, all were contractual. So there was no, my lord, reservation as such. But, my lord, from that part, that, my lord, notice onward, that is in October 2024.
reservation with regard to what persons with disability.
Not only that, my lord, other reservations will also come in, my lord. Statutory as well as, my lord, social reservation. My lord. So that was the decision
For contractual appointment.
for contractor. Ultimately, Article 14 and 16 will be always there. And coupled with that, my lord, they thought that, my lord, the reservation will now be, my lord. And, my lord, probably, my lord, there is in affidavit that it's the government who has finally directed to act upon in that manner.
Right, but the government is also answerable. Why wait until the selection is over? And all of them need not be rejected, even if you apply reservation.
Lordship.
Has anyone
Yeah.
worked out the?
Yes, yes. If somebody already reserved candidate is here in the select list. Could be. Yes, no. Whether yes, the posts are still there or not, my lord, that will be. Oh yes, it's not to be filled out. You filled out. Yes.
What is your right?
my lord, I am relying on Supreme Court judgment, lordship. Leftist full bench decision of the Honorable Supreme Court, lordship. Paragraph 41.
No. You can't just refer to paragraph 41. Tell us the facts of the case you are referring to.
My lord,
What is the matter about?
my
Why
lord,
are you relying on?
here is also, lordship, the selection process was cancelled. And this Honorable Court, lordship, has decided paragraph 41. May I read, lordship, paragraph?
No, you read the facts and tell us what is the.
Yes. My lord, paragraph 2. My lord, some advertisement was issued inviting applications for appointment of lordship post of translators.
Here is a change of fixing of the
Yes.
marks. Cutoff mark.
that was the change during the midst of selection.
But this is nothing to do with reservation.
My lord, para, if you lost it,
Changing of cutoff mark is the criteria for selection.
Yes.
Reservation
regarding the selection,
is prescribed under the constitution that it needs to be done wherever it is called for. Yes, para 41.
para petition.
Hmm.
Thus, in the light of the decision in Shankar Das Supra, a candidate placed in the select list gets no indivisible right to be appointed even vacancies are available. Similar was the view taken by the court in so-and-so, where against 15 vacancies, only top 7 from the select list were appointed. But there is a caveat. The state or its instrumentally cannot arbitrarily deny appointment to a selected candidate. Therefore, when a challenge is laid to a state action in respect of denying appointment to a selected candidate, the burden is on the state to justify its decision for not making appointment from the select list. Conclusion, Lordship. The recruitment process commences from the issuance of advertisement calling for application and ends with filling up of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rules so permit, or the advertisement, which is not contrary to the extent rules so permit. Even such change is permissible under the extent rules or advertisement. The change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. My lord, your lordship may kindly come to last. Your lordship may skip 3, 4, and 5.
Yes.
Paragraph 6. Placement in the select list gives no indefeasible right to appointment. The state or its instrumental for bona fide reason may choose not to fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list.
Now you have to show us whether the decision taken by the department to enforce, implement
Okay.
reservation is arbitrary.
My lord,
Is it arbitrary?
policy lordship regarding
Will
lordship,
it amount to a change of rules in the game?
my lord, some other post on the same advertisement lordship, they have filled up.
You are not claiming their appointment. Are you saying that you had also applied for or is eligible to be considered for those posts which where the appointment orders were given?
Yes.
Without taking into consideration the reservation, etc.
My lord, is the advertisement.
In essence, you are asking for a negative equity.
My lord,
Revelation work.
in the advertisement, there was no mention about the reservation policy. In the affidavit also, lordship, they are saying that no policy of reservation was followed earlier. And only by during the midst of the selection, already lordship selection process has over. Selection is published. After that, lordship, they are taking the decision that reservation is to be followed.
So tell us that this judgment is not an authority for what you are submitting, doesn't support your case. This is the judgment where two different judgments were considered whether they are in conflict with each other. And it has been held
Yes,
they are on two
that
different.
is not in parallel to lordship reservation policy. But so far reservation policy lordship, I have not having with the research judgment. But my lord, that decision, whatever they have taken, Lord,
You show
they
us
could
that the decision which they are taken is contrary to law, policy, judgment of any court. But that you agree that you are a selected candidate. We agree with you. Even the judgment you are referring to says, besides other judgments, that you have no indivisible right to be appointed. It is
yes,
selected.
indivisible. They may not get indivisible right, but the state authority lordship,
But you have not challenged the decision. Have you asked for a decision that what is the policy decision on the basis of which they have cancelled the selection? Have you ever
My
made
lord,
any attempt to
my
seek
lord,
that?
in the impugn notice lordship, they have not mentioned
They
that
may not mention it, but have you made any attempt to get that information from the department?
now it is only in the affidavit lordship, they have come with that ground.
Therefore, we are dismissing your petition. No merit.
But other post on the same day lordship on 13/3/2024.
You are saying that other posts appointed without following reservation.
Yes,
In your post, they are following reservation. So therefore, in your post also, no reservation should be followed.
on the same
In your
advertisement
case, that
lordship.
reservation is contrary to law, should not be followed. Or in these are posts which are excluded from the purview of reservation.
So far reservation is can it be taken up on Tuesday next lordship, I will place some judgment on that.
So there are judgments and judgments. We are not inviting judgments from you. We want to know what is the basis of your case. You don't even know the reason. You have not even made any attempt to find the reason.
No, it
You
is
have come to the court, hoping that the court will call for the record. It will make life easier for you to find out what is there in the record. That's not the job of the court.
but it was their duty to disclose the reason of
It
cancellation of the
is your
selection.
duty to ask. What stopped you from asking it? They have cancelled the reservation. You are agreed.
But that has not been disclosed in the impugn notice.
They have stated in the affidavit.
Affidavit,
Relying on-
only in affidavit lordship they have come with that stuff.
All right, Tuesday. But we don't find merit. We are only deferring the discussion till Tuesday. Based on the date. Wait for the spot. Tuesday.
You may kindly take the matter along with the today's series, Lordship, 8 to 26. Similar matter.
This matter it is submitted that this matter also raises question which are pending before the court in a bunch of writ petitions where the lead case is WPC 2301 of 2024. This case along with the writ petitions.
Matter we have filed a affidavit
Hmm.
on behalf of the department matter.
Which department is it?
Number 4.
What department?
Transformer.
Transformation Department. That's
That's for number 4.
counsel for the Transformation Department submits that affidavit has been filed. At least along with those writ petitions.
Like
Ms. D. Bora for the respondent. MS so and so appears for the respondent. Yes.
We have raised certain issues, but they haven't replied yet. Let us see.
Okay. We'll take up the admission matter. Yes.
The other day, I placed the writ petition and the relevant documents annexed there to Lord. Today, I would like to place the affidavit filed by the state, 2 affidavits. The relevant paragraphs, Lordship, I would like to place how the development had taken place.
Yeah.
Lordship, please should take the affidavit filed by Rupkamal Rabha. It is dated
in the month of July 2024. Lord. The date is not here, but it is starts from page number 221.
Rup Kamal Rabha.
Rup Kamal Rabha. So I would like to place the relevant paragraphs, and thereafter I will place few judgments on the point, and I will close my submission. So paragraph 4.
Yes.
Pursuant to a selection process initiated by Government of Assam in the Department of Personnel, Monsoon Borkakoti was appointed to the post of Assam Land and Revenue Circle, junior grade, by notification dated 9/1/2019. Subsequently, the service of petitioner was placed at the disposal of Revenue and Disaster Management Department for posting as circle officer by notification dated 24th January 2019 and was posted as circle officer Margherita in the district of Tinsukia. A self-styled group in the name and style of Anti-Corruption Liberation Union lodged a complaint with the authorities about the genuineness of the writ petitioner's OBC certificate, as her father belonged to general category. The matter was placed before the state-level scrutiny committee under WPT and BC department to examine the genuineness of the petitioner's OBC caste certificate 13/11/2006. In terms with the guidelines of the Honorable Supreme Court, the petitioner appeared before the state-level scrutiny committee in connection with hearing regarding the veracity of her OBC certificate dated 13th November 2006. Thereafter, the state-level scrutiny committee by order dated 26th February 2021 recommended cancellation of the OBC certificate of the petitioner. In view of the aforesaid recommendation, the Deputy Commissioner Jorhat by order dated 1/3/2021 cancelled the OBC certificate. Subsequently, the Secretary to the Government of Assam Personnel Department by order dated 12/3/2021.
This is at the stage of show cause.
Prior to that, that is the first beginning.
No. The challenge in the writ petition is what? The show cause.
Here it is the second round of issue.
What are you challenging here? What are you saying? So there is a second, there is a second inquiry leading to a show cause.
Yes.
You have not replied to the show cause. Right. And now the matter is to be decided by the scrutiny committee.
Now, yes.
So it is at this stage that you have come before the court.
Yes. And so far as that second inquiry is concerned, whether we can do it or not legally, that I will place the judgments I have already shown also. So these are the developments, how the first rounds went off. Thereafter, Lordship will kindly come to page 225, Roman 4. The background I have given from that paragraph. Pursuant to the order dated 24/11/2022 in WPC 2286 and the subsequent order of 17/2 passed in WPC, the matter relating to the service of petitioner is under consideration of the higher authority of the government. Why this second inquiry was contemplated and how it evolved, that development we are explaining here, Lord. The authorities have explored the available legal remedies against the order dated 24/11/2022 in WPC 22. That is the first order by my Lord Justice Jameer's order, Lordship, where he had relied upon the verification report of the vigilance officer, and same was upheld by the division bench also. I placed both the judgments on the first day of my hearing and obtained legal opinion as regard to the service of petitioner and follow-up action to be taken in view of the Honorable High Court's order as mentioned above. In the legal opinion, displeasure has been expressed as regard the manner in which the caste verification report dated 21/10/2019 was submitted by the CID on the basis of enquiry report dated 3/10/2019. I have already placed this also. Again, I will come back to this report. Submitted by the inspector of CID and also pointed out various issues, and it was suggested that the judgment in WPC 2286 and all subsequent orders requires to be challenged before the appellate forum. However, in view of WA 42/23 filed by Anti-Corruption Liberation Union against the judgment of 24/11/2022, should be 2021, yes, 22, and dismissal of the aforesaid appeal by judgment dated 1/6/2023. the department could not file the appeal. The department was further advised to prefer SLP before the Honorable Supreme Court in that event. The competent authority on 14/6/2023 has also directed Principal Secretary, Home and Political and Personnel Department to examine as to whether there was malafide intent or misconduct on the part of the concerned SP CID and the Inspector of CID in reference to the caste certificate verification report submitted by them. Accordingly, the Personnel Department requested the Home and Political Department to make an inquiry into the manner in which the caste verification report was submitted by the CID officials. In response to the same, the Joint Secretary to the Government of Assam, Home and Political Department by letter dated 14/11/2023, furnished the letter dated 7/8/2023 issued by the IGP CID Assam stating inter alia that there was no malafide intent or conduct on the part of the SP CID Assam in connection with the enquiry. However, the enquiry reveals that the Inspector Dibbojyoti Datta, the then inspector, has made a perfunctory enquiry while verifying the caste status of the petitioner, and various vital aspects were not considered by the enquiry officer. The Joint Secretary to the Government of Assam and Home and Political Department also provided a copy of the enquiry report dated 31/7/2023, which was conducted to ascertain whether there was any malafide intent of conduct on the part of the earlier enquiry officer or not. This Lordship will find it Annexure 4, that page number 271. This is dated 14th November 2023. Here it has been written by the Joint Secretary to the Home and Political Department to the Secretary Personnel Department. With reference to the letter on the subject cited above, I am directed to inform you that as stated by the Office of Additional Director General of Police, CID, Assam, by letter dated 7/8, that is in the month of August, there was no malafide intent or conduct on part of the Superintendent of Police in connection with the enquiry. Necessary enclosures in this regard as furnished by the Office of the ADGP is attached herewith for favor of your taking action. Here they have not mentioned, this is the covering letter. Next page, Lordship will see the document which is annexed. The letter dated 7/8/2023. This has been issued by the Inspector General of Police, CID, to the Additional Secretary of the Government of Assam, Home and Political Department. Here, that second line was very important. First paragraph. With reference to the subject cited above, I would like to inform you that an enquiry was conducted into the matter. The enquiry was conducted by Sri Punamjit Nath, APS, Deputy Superintendent of Police. The enquiry revealed that Inspector Dibbojyoti Datta, the then inspector, had made a perfunctory enquiry. However, it has been ascertained that there was no malafide intent or conduct on the part of SP CID. The enquiry report along with the enclosures submitted by the enquiry officer are attached herewith and forwarded for your kind and further needful action. Next page is the enquiry report, 31st July 2023. So this is the interim within the department, the preliminary enquiry they have done. The final enquiry was done by different person, Lordship, which was completed on 26th December 2023. Here, Lordship will see submission of additional information. Memo dated 22/6/2023, reference writ petition Monsoon, Borkakoti versus, and everything was done because when it was found out that there are two different opinions, one by the vigilance officer that she belongs to SC, OBC, whereas the circle officer who was also submitting the report on behalf of the Deputy Commissioner Jorhat to the scrutiny committee, that she does not belong to OBC. So these two agencies found two conflicting opinions, and therefore the government wanted to know whether the police authorities or the CID authorities, whether they have done the enquiry properly or there was any malafide intention or not, or some biasness or not. That was being examined. Then next page, Lordship will see. First page, 273, last line.
Yes,
That
just 1 minute.
or written argument. এইখন বনালে নে?
Yes, please.
Then submission of additional information, 31st July 2023. The detailed last line, the detailed report in connection with the matter has already been submitted on 17th July. The following observations are made. In the OBC certificate issued to Monsoon Borkakoti by All Assam Backward Classes Association on 13 November 2006 and countersigned by the then ESC Additional Deputy Commissioner Jorhat, in the name has been mentioned as the spelling is incorrect. Sri Digonto Borua village headman of Chekonoi Dhora Gaon, Jorhat East, under whose jurisdiction Monsoon Borkakoti currently resides, had provided a copy of the letter he received from Surendranath Bora, the then village headman of Doirongia Gwal Gaon, informing that late Sibaprasad Borkakoti, father of Santanu Borkakoti, along with his family, was residing in Doirongia Gwal Gaon, Moza Misamara, district Golaghat before 1950, and they belong to Coast community. The father also family also become Coach. Sri Surendranath Bora, the then village headman of Doirongia Gwalgaon, denied issuing any such letter confirming that they belong to Coach community, thereby contradicting the statement of Sri Digonto Borua, village headman of Chekoni Dhora Gaon, Jorhat East Revenue Circle. Next, Monsoon Borkakoti had received a letter dated 26 March 2019 from the Deputy Commissioner, Jorhat, asking her to bring the original documents for verification. Later, the aforesaid letter was found to be fake, for which R.A. Korati IAS, the then Deputy Commissioner, had submitted a written complaint on 3rd April 2019 to officer in charge of Jorhat PS against unknown persons for faking her signature and official seal. On receiving the complaint, a case was registered by Jorhat PS case number so-and-so, endorsed to so-and-so for investigation. The following points were not incorporated in the earlier Enquiry Officer's Inspector Dibojyoti Dutta of CID in his report submitted to Superintendent of Police CID on 3/10/2019. The above mentioned observations has been taken into account. It deemed fit to ascertaining the malafide intent on the part of the previous Enquiry Officer submitted for favor of current result. So this is the preliminary inquiry where it was found that EO, Enquiry Officer, was not doing his job properly. Some major discrepancies were found. Therefore, it was subsequently sent to the government. Lord will again come to page 227. So all these documents were submitted to the government on 14/11/2023. So Roman 5. After receipt of the aforementioned communication dated 14/11/2023 from the Home and Political Department with the enquiry report, the department has again to take up the matter to obtain legal advice as regard to the further action to be taken in the matter in view of the subsequent developments as stated above, and accordingly as per the legal advice, the department had preferred a review petition, being review petition number 6 of 2024. Further, under the aforesaid facts and circumstances, the competent authority has suggested for fresh enquiry. So this is a proper enquiry now, vigilance officer, into the caste certificate of the petitioner, and also to initiate a disciplinary proceedings against the inspector of CID, Sri Dibojyoti Dutta, as per the report submitted by him earlier, has been found to be perfunctory enquiry report. Pursuant to the direction issued by the competent authority as stated above, the Superintendent of Police CID Assam, Ulubari, by letter dated 26th December 2023, submitted a detailed enquiry report on the status of the caste certificate in respect of Srimati Monsoon Borkakoti, as submitted by the enquiry officer Srimati Moromi Das, APS, Deputy Superintendent of Police, CID Assam. The aforesaid enquiry report submitted by CID clearly indicates that Monsoon Borkakoti is not entitled to the OBC certificate as her father belongs to the general category. The report further clarified that as per notification dated 3/10/2019 issued by the Ministry of Social Justice and Empowerment, Government of India, and the notification dated 21/5/1977 issued by the Ministry of Home Affairs, the petitioner is not entitled to claim the benefit of OBC as her father belongs to general caste and her parents were never separated, divorced, or she received all kind of support from her father. That report I have already gone placed before this honorable court. Next paragraph. After receipt of the aforesaid enquiry report from the CID, the personnel department by letter dated 27/11/12/2023 forwarded the same to the secretary to the government of Assam Social Justice and Empowerment Department for taking necessary action at their end. In response to the same, the Director Welfare of Scheduled Castes and Backward Classes Assam had issued the so-called notice dated 28/12/2023 to the petitioner, asking her to explain the reason which led to her to obtain the caste certificate of a caste to which she does not belong. The deponent further states that earlier an enquiry report dated 3/10/2019 on the caste status of Monsoon Borkakati was submitted by Sri Dipojyoti Datta, and the aforesaid enquiry conducted by Dipojyoti Datta was subsequently found to be not to be proper and perfunctory, and for submission of such a perfunctory report, the authorities have already initiated departmental action against Dipojyoti Datta inspector, and same has been initiated by IGP administration by order dated 3/1/2024, that suspension DP, which is going on. Now coming to page 231. Because there was another single judge's order that she should be reinstated. The contempt case was also going on at that point of time. And the government, after giving an undertaking before the court that we are going to reinstate, paragraph 15, on 18/6/2024, she was reinstated. Annexure 11. So now there is allegations that the husband of the petitioner belongs to some political parties, etc. Because of that, this is going on. That we have denied, because what we have nothing to do with the political spectrum. Whatever is done, because she was originally given the service, she joined, complaint came, enquiry done, 2 conflicting reports came, the scrutiny committee decided against her. She came before the division bench, a single judge got a favorable order. She went to the division bench, got a favorable order. When the government at that stage examined everything, found that the original report on the basis of which the foundation of both the single judge's order of November 2023 and the subsequent order in the division bench, in both the judgments, the reliance was on the report, as the report was in her favor, and following the Madhuri Patil's case also, the vigilance officer report is to be believed and it has to be accepted. So on that ground, we have examined the thing, whether the report on the basis of which the Honorable Court give due importance, we wanted to examine, and it was found that he had not done his enquiry properly, and it was a perfunctory enquiry. So it has nothing to do with all these political statements made in the writ petition. Now paragraph 18/232. As regard to the statements made in paragraph 24 of the answering deponent while reiterating the statement made in paragraph 4 in the instant affidavit in opposition, begs to state that allegations against the petitioner Monsoon Borkakoti is of serious nature, alleging her of obtaining OBC certificate for which she is not eligible and availing reservation facilities in government services on the strength of such certificate. This raises serious concern about depriving genuine candidates of reserved category. As such, the allegations need to be thoroughly investigated and addressed all concerns arising out of suspicion of fraudulently obtained caste certificate. Accordingly, Home and Political Department requested to examine through the ADGP CID regarding the matter of earlier report dated 16/6/2023. In response, so this is a repetition of the basic things. Now coming to paragraph 20/234. With regard to the statements made in paragraph 25 of the writ petition, the deponent respondent begs to state that the Home and Political Department by letter dated 26/12/2023 furnished a report submitted by CID dated 26/12, which reported that Srimati Monsoon Borkakoti resided in her maternal home in Jorhat, and by her admission, the parents are living together and have a happy married life. During the inquiry, it was well established that Sri Monsoon Borkakoti's parents were never separated and or nor divorced. Her father took care of all along. She did not suffer from any disabilities socially, economically, and educationally. She had the education in the elite institutions all along, Lord. And all along she stayed in the heart of Jorhat, which is a very posh locality. Therefore, Srimati Monsoon Borkakoti ALRS is not entitled to claim the benefit of OBC as her father belongs to the general category and her parents were never separated, divorced, or she received all kind of support from her father. The report of CID also revealed that Dr. Santanu Borkakoti, father of Monsoon Borkakoti, applied for OBC certificate in February 2019. When that complaint came and the inquiry started in the first round, they wanted to misguide or mislead the whole inquiry process. So father also started applying. Now what develops is very interesting. During the inquiry, a fake OBC certificate issued in the name of Dr. Santanu Borkakoti, bearing caste certificate number 94497 dated 19/3/2019, was collected by the inquiry officer, and it is assumed that the original copy was with the beneficiary, namely Dr. Santanu Borkakoti. To ascertain the facts as regard the document, when the inquiry officer, the counterfoil he could recover, but the original copy, the other side of the counterfoil, it is with them.
Which is,
Our matric certificates also.
which is not produced.
Which is not produced. And the daughter created the hurdle. To ascertain the facts as regard the documents, when the inquiry officer intended to question Dr. Santanu Borkakoti, he was restrained by Srimati Monsoon Borkakoti from meeting him on the pretext of his ill health. Further, the inquiry found that Dr. Santanu Borkakoti, father of Dr. Monsoon Borkakoti, tried to manipulate the inquiry by applying the OBC certificate in 2019, for which he is not eligible, and also by procuring one fake OBC document from Golaghat district. For such dubious method adopted by Dr. Santanu Borkakoti, father of Monsoon Borkakoti, appropriate criminal proceeding was suggested. Now it has culminated to charge it at this stage. In view of new facts and circumstances brought into light through the report submitted by CID on 26/12/2023, and it also furnished to the Social Justice and Empowerment Department for taking necessary action. And on the strength of the finding in the report, the Director of Welfare of SC and BC initiated inquiry by issuing the so-cause notice, which is put to challenge in the present proceedings. Further, the report of CID clearly indicates that Srimati Monsoon Borkakoti is not entitled to claim OBC. As such, the government has instructed the Social Justice and Empowerment Department to ensure that there are no procedural lapses in carrying out the inquiry strictly as per the guidelines of the Honorable Supreme Court on a fast-track basis, and the ADGP CID to ensure that the proceeding against the father of petitioner, Srimati Monsoon Borkakoti ALRS, are taken into their logical conclusion urgently. These instructions have been communicated to the concerned authorities of Social Justice and Empowerment Department by letter dated 26/2024. Next, coming to paragraph 22. As regard to the statement made in paragraph 28, the answering deponent begs to state that the review petition 6/2024 was disposed of by the Honorable High Court in order dated 28/5/2024 as not pressed for, and taking note that the government has decided to proceed with the inquiry initiated against the petitioner. Lordship will pause for a moment. That order I would like to place, because according to them, we have exhausted all our rights. This order of withdrawal, Lordship, page number. Yes, page 349. At that point of time, two parallel proceedings was going on, Lordship. One, that so-cause notice was issued. She was to participate before the scrutiny committee. On the other hand, the review is also going on by the state, saying that subsequent developments, a lot of startling facts have come into light. So we want to go for a review of the learned single judge's order, division bench order. So here, the Honorable Court put us two questions. Which proceedings you want to pursue? Either review proceedings or the inquiry.
There were two reviews filed.
So, Lordship,
Two reviews filed or one review?
we filed two reviews. One review was that we filed a first review in my Lord Justice Debashish Borua's order where there was a direction that he has to be reinstated. The Honorable Court says that as because the edifice of the whole judgment was the learned single judge's order of November 2021, 22, my Lord Justice Jamir's order. So as that order is still holding the field, therefore, without touching that order, I cannot pass any order for review of the order of reinstatement. But learned single judge's order was merged with the division bench order of 1/6/2023. The division bench order filed, the appeal filed by the third party. So we filed a review against the division bench order of 1/6/2023. So therefore, this review application, the Honorable Court gave us the option. Either you pursue that or you pursue this. 1 week's time was given to us, or maybe 15 days time was here. We examined the whole matter and finally decided the learned AG on instruction has submitted that the state does not want to praise this petition since they are pursuing with the inquiry initiated by them against the petitioner, that so-cause notice proceedings. That is why we wanted to proceed with the so-cause notice, because ultimately she has to get the opportunity as per Madhuri Patil's case, that when something is found against her and there is a question mark against the caste certificate, she should get due opportunity for compliance of the principle of natural justice, also to rebut whatever is founded by the subsequent inquiry. So therefore, we wanted to pursue and we withdraw. We said that we do not want to praise this review application because we are now following the other process which is given by the Madhuri Patil's case guidelines.
The review was sought for the ground of
Review was sought for because 1/6/2023, the division bench upheld the November 2022's order, my Lord Justice Jamir's order. In both the cases, the whole basis of granting relief to the other side, that the petitioner, is that the report of the vigilance officer, which was in their favor. So now we have found that the report itself is wrong, incorrect. Improper inquiry was done, perfunctory inquiry was done. Some vital aspects were left out. He has given more opinion than facts. So whether we have a right to reopen an inquiry or not regarding any question raised against a caste certificate. So may I proceed now? Paragraph 22, the second line. So the review petition was disposed of in later by as not praised, and for taking note that the government has decided to proceed with the inquiry initiated against the petitioner. The deponent further respectfully states that it is the settled position of law that de novo or fresh inquiry is permissible in case it is found that the earlier inquiry into the caste certificate is vitiated by fraud, or when the same was issued without proper inquiry. In my case, it is not proper inquiry. Further, in view of the categorical findings on the basis of the facts discovered during the inquiry, it is abundantly clear that under no circumstances, if the facts unearthed during the inquiry are correct, and through the writ petitioner is not entitled to get the OBC certificate. If the government remains silent or inactive upon discovery of such vital facts on the basis of which no OBC certificate can be granted to the writ petitioner, it will amount to allow a non-deserving candidate to secure undeserved and undue advantage of reservation in place of a deserving and genuine OBC candidate in the matter of employment. In that view of the matter, after the inquiry report dated 26/12/2023 was received, a conscious decision was taken by the competent authority to issue so-cause notice to the petitioner to afford opportunity to respond to the findings of the inquiry. This exercise has been done in due compliance of the procedure laid down by the Honorable Apex Court in Madhuri Patil's case. And while doing so, there is no violation of any rights of the petitioner, and the action of the state government cannot be treated as illegal, mala fide, or arbitrary. So we are very clear, Lordship, in our exercise. We are giving them an opportunity. Having one round of inquiry and two subsequent judgments, when the whole inquiry subsequently it has been found that it is not proper. Whether at this stage, whether the court will close their eyes or whether the government should close their eyes. Ultimately, I'll place the judgments of Supreme Court. These reservations are given to the actual genuine candidates. These are not a general right created for all people. For some special people who are deprived in their social status, they are given.
So they must belong to that.
Provided they belong to that. Now, if she belongs, if she proves that the second inquiry where lot of vital facts are there,
So the certificate is meant for only members of the committee.
absolutely, Lord.
Whether you get benefit or not is a.
Yes, and for the government, whether the writ petitioner is in that position or some XYZ is in that position, it does not matter to the government, but that XYZ should be genuinely belonging to that candidate. A general candidate should not usurp their position for whom it is actually targeted.
What is alleged, and if it is proved, then everything.
Yes, that is why we are trying to find out. We are not saying that whatever our second inquiry is 100% correct, but facts on the materials we have given, and she can rebut it. She can leave evidence to prove that she actually had led her life under the practice and customs of OBC. But when she studied in a very the missionary school in Jorhat, then in Cotton College, remained most of her time in Guwahati, in Silpukhuri, then also lived in a very posh and central location of Jorhat. When father and mother are living together, they are living in a house built by her father and mother jointly. The land may belong to the mother's family, but both husband and wife are happily married there. And he was working in Dergaon, Golaghat, and Jorhat because he was a health department doctor. So his service, his professional commitment led him to Jorhat. If he was working in Kamrup or Goalpara, he would have lived in Guwahati. So it has nothing to do that this girl, writ petitioner, lived in Jorhat, and because of her mother belonged to Coach. And mother also procured a certificate in 2019. Mother was a state government employee. The Honorable Division Bench wanted to see the record, how it was recorded. In 2006, the record showed that she is OBC. But she had a OBC certificate only in 2019. So somebody must have done something mischief, because when the father can procure a OBC certificate in 2019.
Settled now in view of the division benches.
Direction. So this manipulation can always take place. But the mother also, in the subsequent inquiry, it was found that mother also produced a OBC certificate issued in 2019. Father also produced, and father and the daughter herself says, my father belongs to Kolita community. So in that situation, whether it is an ideal situation for the government to close his eyes and put everything in a cold storage, or we can become active little bit to find out what is true. We do not want to deprive her without giving her opportunity. Therefore, the so-cause notice, there is absolutely no infirmity, no arbitrariness. Their only ground is that already division bench have passed an order, already learned single judge has passed an order. That cannot be a ground. Lordships in umpteen number of cases reviews judgments of this honorable court when subsequent facts comes into light. The principle of review is available to a judicial order. The principle of also review also belongs to the administration also. For the executive also, if they have come to notice, it has come to their notice that a wrong has been committed. A wrong has been committed. Can that wrong be so sacrosanct that it cannot be touched? In my humble submission, it is the law of equity, law of common sense, law of prudence makes it compulsory and compel to rectify the mistake. We cannot take advantage of negative equality. If something is wrong, we have to rectify. We in your life also, I have done some mistake. I have always make an endeavor to rectify my mistake. So when it has been found that Dibbojyoti Datta has done, let us read his opinion, how he has done that inquiry. It is quoted in the judgment itself. 244, the petition. in the writ petition. Page 245 writ petition. So he was given in charge of enquiring 3 persons case. One is Monsoon Borkakoti, the other one is Vicky Kosal and another person. So regarding Monsoon Borkakoti, page 244, Lordship will see, as entrusted, I visited the middle portion. As entrusted, I visited different given locations of the LS persons and found that findings which have been presented below. In respect of Srimati Monsoon Borkakoti, I visited her parents' address and present address at Golaghat and Jorhat. In course of enquiry, it is found that father of the LS, namely Dr. Santanu Borkakoti, born and brought up at Silpukhuri, Guwahati, followed original rights, the rights of Kolita community, and got appointed as medical officer who was posted at Jorhat. The said doctor got married to a lady of Jorhat hailing from Koch OBC community and to reside at matrimonial house wherein the LS Miss Monsoon Borkakoti got birth at her mother's house on 12/4/1990. And since then, she started her education at Jorhat and accepted the customs of Koch community, from where he has found this, accepted the customs of Koch community. There should be some vital material facts. He cannot just give an opinion without basing upon any materials which can have some correlation with his finding. During 2006, while she was the student of class 9, she applied for OBC certificate on the merit of her mother's custom. It is a fact that the father of the LS, though got appointed as MBBS doctor, however, he was not moved for OBC certificate. He had procured the OBC certificate. This report is of October 2019. And the father got the certificate few months earlier. I placed that certificate also the other day. Certificate. Just 1 second, Lord. Yes. Page 329 of my affidavit. 329.
329.
329. So this report is of 3rd of October 2019. And page 329, the father's OBC certificate, which was discovered during the second inquiry done by the APS lady, APS officer. So this is of 19th March 2019. That means about 7-8 months earlier, he procured Santanu Borkakoti, so-and-so, police station Dergaon, district Golaghat, Caste Koch Rajbongsi, identified by GB, that is the Gaon Bura. So straightway, the opinion given by Dibbojyoti Dutta in his first report, that first report date is, Lordship will find that date. 3/10/19. So it is a fact that the father of the LS, though got appointment as MBBS doctors, however, he was not moved. I do not know the grammar. He was not moved for the OBC certificate as he was not born at Koch community. So this is a direct fault in his finding.
This is the what? Counterfoil.
This is the certificate, photocopy.
The original is not available.
Original, they did not allow us to. The original counterfoil we have found.
But the certificate was not there.
Certificate is not there. So all these things will come out in their reply. I mean, reply to the show cause notice. It is pertinent to mention that in respect of issuing OBC certificate, Honorable Supreme Court passed a verdict. So now, without any disclosure of facts, foundation of his opinion, he comes to the law laid down by the Supreme Court. May I read it, Lordship?
You are reading from?
I am reading from page 244, the last part. Then coming to the next page. So what he has said, the OBC, and he was not born in Goa. It is pertinent to mention herein that in respect of issuing OBC certificate, Honorable Supreme Court of India passed a verdict referred to civil appeal number so-and-so of 18 January and in connection with appeal of Honorable Supreme Court past judgment in the child generally belongs to father's caste. However, the child can claim mother's caste also in certain situations. What are those situations? He have to find out the ground realities. Without those situations, because the girl can definitely in the inquiry, she can lead evidence that I am deprived socially, financially, and educationally, economically. Those things are not here. So she can claim mother's caste also in certain situations. Those situations are very vital. He did not make any endeavor to find out those situations. And if a child is born and brought up at the house of her mother, who is hailing from other community than that of her father. So this is an own finding. It is a fact that the judgment promulgated not directly reiterate to OBC community. However, the situation incorporated carried the ingredient for which the LS Monsoon Borkakoti is seen to be entitled for obtaining OBC caste certificate. Moreover, the issuing agency clarified that the certificate issued is genuine and issued from their office. So that ingredient word, what are the ingredients? He must have some ingredients to form an opinion. That ingredients was not. That is why it is an incorrect, improper, and perfunctory inquiry. The photocopy of OBC certificate issued by the President, All Assam Other Backward Classes Association, Guwahati. Copy of certificate issued by local Gaonbura, namely Digonto Borua of Sekonidhara. They have all denied now. Number 3, Town Moja, East Revenue, Gaon Local Bura certificate issued by Torun Chandra Hazarika, Gaonbura of Betioni, Kakoti Gaon, Moja, Dhikial, District, Golagat. Copy of judgment passed by the Honorable Supreme Court in connection with civil appeal. Number so and so decided on 18 January of 2000. I enclose here it. As such, it is established, without any facts, it is established that the allegation brought against Srimati Monsoon Borkakori, daughter of Santanu Borka, resident of Clubhouse, that is the post locality of Jorhat, is based on no truth. The complainant perused only the father's caste, but did not go through the legal findings of the Honorable Supreme Court. So this is his opinion and findings. It is not very clear this side, that side. He is giving more opinion than facts. No disclosure of facts. His basic fact is that the father did not have a caste certificate. That is incorrect. She is staying in mother's house, but along with the mother, father also stays there. That means she is staying with her family. Who is the title owner of that land? That is not critical or crucial. So she is living with her parents. So according to him, she lived with her mother, as if the father is discarded. Strange father, no. Father and mother all were happily married. They have jointly built that house, which is the finding in the second inquiry. This lady officer who did the final inquiry, Lordship, she made all the family members there, all the neighbors, all the opinions, all are recorded. It's a very bulky report. So they have to counter all these allegations now, the findings of this subsequent inquiry. And in my humble submission, the Honorable Court, by taking a cue from the Madhuri Patil's case, where the guideline says that the opinion of the vigilance officer has to be accepted. So taking a cue from that judgment, this report, rightly, wrongly, it was not tested at any level till that moment. The Honorable Court has rightly accepted this, because there is no contra, because we submitted this report to the court. Now, when government wanted to go to Supreme Court or to comply with the orders, decided to know that why there are two opinions of the same facts. The circle officer and deputy commissioner's officers report in Jorhat is against her, and the CID officer's report is in her favor. So for the government, Lordship, these are two wings of the government, of the state mechanism, but these are state instrumentalities. So when two arms of the government are giving two conflicting opinions, duty cast upon the government to find out whether there is any flaw in the reports. When one was found, that suppose that CID report was absolutely correct, that would have closed the whole chapter. There is no requirement of going any further. by complying with the Honorable Court's order, by reinstating her and rejecting all the claims of the other complainants, the government could very happily close the whole chapter. If the preliminary inquiry of 31st July 2023 and the subsequent report of 26 December 2023 were in tandem or in sync or in the same alignment with the report of Divyajyoti Datta filed on 3rd of October 2019, these whole events would not have arisen at all. But when government found some very startling facts in the subsequent inquiry, initially we tried to go to the division bench with the reports, everything, by filing a review application, but that will not lead us from the road away from having an inquiry as per the Madhuri Patil's guidelines to give them opportunity. So the appropriate authority to examine the veracity of the findings of the subsequent inquiry lies with the scrutiny committee. That scrutiny committee has issued the show cause notice, which is put to challenge. If tomorrow the scrutiny committee may accept their version also, that she actually deserves to be OBC, then we have nothing to do thereafter. But if it is contradictory, then we have to cancel the certificate and consequential action will follow. I am not going to that familiar issue. Familiar issue also will enter later stage. Because the both father and mother are government employees and their income is much, much higher than 8 lakhs rupees cap. So that was also missed out in 2019 when he got the appointment. But that is a different subject matter. So now, what are the differences between the first inquiry and the subsequent inquiry? I try to make a list. So, left-hand side, inquiry report dated 3/10/2019 by Divyajyoti Datta and the other one by the lady officer, APS officer. So in the first side, left-hand side, Lordship will see, the inquiry officer or the vigilance officer visited her parental address and present address, Golaghat and Jorhat. Father Santanu Borkakoti was born and brought up at Silpukuri and followed the original rights of Kolita community and got appointment as medical officer who was posted in Jorhat. Suppose he was not following Kolita community's ritual and he was staying in Koch community family. He have to have a findings here. Next, he got married to a lady at Jorhat hailing from Koch community and resided at matrimonial home wherein Monsoon Borkakoti was born. Whether it is a matrimonial home or it is a parental home, he is giving opinions only. Now, in the subsequent report, we have found that the father has contributed whole money for building that house. These are the opinions given by all the family members. That the father has invested and jointly with the mother built up that big mansion there. Next, Monsoon Borkakoti stated education at Jorhat and accepted customs of Kochra committee. Where is Cotton College from 2009 to 2015, where she did very good in her studies by residing in Silpukuri, Guwahati. So this is a straightway incomplete findings on the factual aspects. So Monsoon Borkakoti stated education at Jorhat and accepted customs. So she simply said, I studied in Jorhat only. So where her major education, from class 11 onwards till post-graduation, everything she had done in Cotton College or Cotton University. So this is silent. In class 10 in 2006, she applied for OBC certificate on merit of her mother's customs. Father did not belong to Koch community, no OBC certificate. So there is a OBC certificate which we have placed before this honorable court also. Now on the right-hand side, inquiry report of 26/12/2023. Monsoon Borkakoti is presently residing at Sekonidhara Gaon, number 3, town Moja, along with her parents and younger brother. So father also stays there. So it is not a maternal home. It is a family parental home.
It could be maternal home.
Lordship.
Could be maternal home. But I mean, going by whatever you have stated, doesn't
Yes.
disclose whether it is maternal or paternal home, but family stays together.
Family stays together. So parents, that's why I'm saying parental home. I'm not saying father's paternal home. No, I'm saying parental. The parents are staying together. So it's a parental home. Not paternal home, not maternal home. Her father is residing together with his wife and children. Her mother is working in irrigation department, government of Assam. Dr. Santanu Borkakoti was born and brought up at Silpukhuri, Guwahati. His ancestral roots belongs to B. Kakoti Gaon, district Golaghat, village headman, so confirmed that great-grandfather of S. Borkakoti shifted his residence to Guwahati. Monsoon Borkakoti is the daughter of S. Borkakoti, and they belong to Kolita community, which is a general caste. Village headman at Sekonidhara Gaon confirmed that Purnima Datta, mother of Monsoon Borkakoti, belongs to Koch community. Monsoon Borkakoti, during her higher studies, she was residing at her father's ancestral home at Silpukhuri from 2009 to 2015. This vital fact was not there in the earlier report. OBC certificate was obtained by Monsoon Borkakoti on 13/11/2006, countersigned by ESC, Jorhat, showing that she belongs to Coast community. Name of the petitioner differently spelled in OBC certificate, which she used for APSC examination. Monsoon Borkakoti admits that her mother belongs to Coast community and father belongs to general category. Visited the office of All Assam OBC Association, Jorhat district, Congress Bhavan, to verify the documents submitted by Monsoon Borkakoti at the time of applying the OBC certificate. Office records available on 2007 and OBC certificate to her on 13/6. So here it is only thing is that office records are available from 2007 onwards. From up to 2006, they have destroyed. So, then 9, visited DC office Jorhat to verify the documents submitted by Monsoon Borkakoti for obtaining. No records found. Actually, there was no record. In fact,
So is it because the records were destroyed?
I doubt. I doubt.
No record.
No record. So they may have good relations and got a certificate without proper verification out. There is due process. I'll place Supreme Court judge. How a certificate has to be issued. There should be due diligence by verifying. Affinity test has to be done. It is not so easy to give a certificate straight away. Next, Lordship, 9.
No records found.
No records found.
No records found.
No records. They said that we do not keep any records. Everything below it should be in the All Assam OBC Association's office.
They have destroyed.
They have destroyed in 2006, but 2007 onwards they have produced the record.
And the certificate was issued in
2006, November 2006. So all these things will come into light when the actual inquiry will take place. Now next, Lordship. Visited, then 10. Dr. S. Borkakoti applied for OBC certificate in February 2019. The complaint came before that. That anti-corruption organization, they raised a complaint, then immediately he sprung into action. Dr. S. Borkakoti applied for OBC certificate in February 2019. Fake OBC certificate 19/3/2019 issued in the name of Dr. S. Borkakoti. Purnima Datta also issued on 16/11/2019. So mother also procured a certificate after the report was issued in October, 3rd November. She procured another certificate in her name.
Why is it said fake certificate in respect of father?
Original certificate, they did not produce, number one. We have to verify. It's a purportedly fake certificate.
So, but the counterfoil is there.
Counterfoil is there. So certificate was not. In fact, Lordship, one thing is very clear. Suppose that certificate is with him. Let the genuine certificate. I mean the genuine document. All along, the daughter, he himself, he was a government employee. He was always recognized as a general candidate in the Health and Family Welfare Department.
assuming that certificate is genuine
genuine.
to the father, in a given situation, you can initiate an inquiry to find out whether this certificate was correctly issued for
And
the-
that inquiry, that search sheet we have filed.
against the father.
Yes, I'll come to. In the second, if it that is the part, Lordship. Nobody will go scot-free here, Lordship. Whatever may be the outcome of the proceedings here. A genuine candidate has been deprived. That is the opinion of the government. Genuine candidate who actually deserves reservations under Article 14 and 16. Ambedkar did not frame this constitution just to give benefit to the
Undeserved.
forward classes people. 11. Official record of Monsoon Borka's brother so that he belongs to general category. So his brother's verification was also done. So this officer went to that college, Betioni College, and he is recorded as a general candidate. He is a present student here. Findings 11. Monsoon Borka's parents were never separated or divorced and were residing together. Monsoon Borkakoti did her schooling from Jorhat and residing in her father's place, ancestral Guwahati, for her higher studies. She falls in the creamy layer. So these are the findings. So huge difference from the first report and the second report. So in that situation, a focus notice has been issued. The only difficulty for us is that on the basis of the first report, 2 judgments were delivered. That is the end of the story for one part. Now, with the subsequent developments, with so many startling facts have come into light, government has proceeded, given opportunity, whether those 2 judgments will bar the present proceedings.
Can we go back to the judgment of the single judge first?
Yes. Yes. The single judge's judgment, Lordship, will find at page 240 of my affidavit. Page 243, Lordship will kindly come there. At this stage, D. Mujumdar, Learned Additional Advocate General, Assam, has produced a record before this court, which contains the inquiry report submitted by the Superintendent of Police CID as Guwahati with regard to OBC certificate of the petitioner. The inquiry report dated 3/10/2019, made by the Inspector of Police CID Assam. The inquiry report is produced herein below. So that whatever I have read out, Lordship. Now, on the basis of this report, how the court went ahead, page 247. A perusal of the inquiry report dated 3/10/2019 clearly indicates that the allegations brought against the petitioner is based on no truth, and accordingly, the closure of the inquiry was recommended. Perusal of the record produced by the Learned Additional Advocate General also indicates that the respondents has proceeded in terms of the procedure laid down by the Supreme Court case in Madhuri Batil, that and final report was submitted on 3/10/2019. Accordingly, considering the inquiry report dated 3/10/2019, the impugned speaking order dated 26/2/2021, issued by the state level scrutiny committee against the petitioner is set aside and quashed. So this report actually led the honorable court to pass an order in favor of it. Then the division bench order, Lordship.
Where is that order?
Division bench,
No, 26/2.
26
Speaking
to
order,
page 96 of the writ petition.
96.
Yes. I have already read it once, Lordship. Page 96, annex 13 of the writ petition, speaking order.
Speaking order was passed against her.
Against her. May I read the operative part, page 101. Under the facts stated above, and after proper introspection and observation, the state level scrutiny committee is of the view that Srimati Monsoon Borkakoti, daughter of Dr. Santanu Borkakoti and Srimati Purnima Dutta Borkakoti, resident of Clubhouse Jorhat, has obtained the caste certificate through unfair means by projecting a picture of having suffered deprivation, humiliation, disabilities, and handicap, which is very different from the reality. Hence, the OBC certificate issued to her should be cancelled by the authority. So this was the order. Now, how the division bench dealt with the report, page 249, Lord. So 1/6/2023, the appeal filed by the third party, that is the anti-corruption organization, the Anti-Corruption Liberation Union. Here, Lordship will find page 4, paragraph 4, page 252. So, Senior Counsel AKB argued on behalf of that appellant, and the Writ Petitioners Council started their submissions at paragraph 4. May I read it, Lordship? Par contrast, so-and-so learned senior counsel representing the respondent placed reliance on the judgment of the Honorable Supreme Court in Kumari Madhuri Patil and urged that the procedure for issuance of a social status certificate and for scrutinizing a false status certificate has been extensively formulated by the Honorable Supreme Court in the said judgment. He urged that in the light of mandatory guidelines laid down by the Honorable Supreme Court in Kumari Madhuri Patil, the complaint with allegations of fraud in issuing the OBC of the petitioner was inquired by the vigilance officer under the SP CID Assam. The inspector of police CID proceeded to conduct an inquiry, recorded evidence during the course thereof, and thereafter submitted a detailed reasoned inquiry report dated 3/10/2019, concluding that the caste certificate held by the respondent petitioner was genuine. He further pointed out that the date of birth of the respondent number is 12/4/1990. The mother of the respondent, writ petitioner Purnima Datta, belongs to Coast community, which became recognized as OBC in the central list of OBC for the state of Assam in the year 1993. He submitted that as the respondent writ petitioner was born before Coach community was included in the central list of OBC, manifestly her birth certificate could not record that she belongs to OBC. However, based on the fact that the girl child was residing with her mother, Lordship will kindly see, this is their submission, not father has become invisible. The council said, based on the fact that the girl child was residing with her mother, father is missing, and was following the customs and rituals of Coast community, a certificate dated 13/11/2006 was issued in favor of the respondent writ petitioner, affirming that she belongs to Coast community OBC. So and so submitted that neither the respondent nor her mother could have entertained a thought that she would get advantage of reservation based on OBC, so as to make a fraudulent attempt to get such a certificate way back in 2006. He urged that the detailed inquiry report 3/10/2019 submitted by the inspector in terms of the mandatory guidelines on Kumari Patil was not considered by the SLEC. So the division bench found fault that the SLEC did not rely upon this perfunctory inquiry report. Now, Lordship will kindly come to how the division bench dealt with this issue. Paragraph 14, page 259.
Yes.
In the wake of the discussions made herein above and in keeping in view of the categorical affidavit filed by the state government authorities before the learned single judge, placing on record the report dated 3/10/2019. We are fair to the court also. At that point of this was the only material with us. Now more materials has come up. Placing on record the report dated 3/10/2019, which was prepared after thorough inquiry conducted by the vigilance officer, that is Inspector of Police CID, in the present case under the supervision of SP CID, concluding that the allegations regarding falsity of the social status certificate of Monsoon Borkakoti was based on no truth. It was the language of the report. The only course of action required to be taken as per the ratio of the judgment of Kumari Madhuri Patil was to accept the said report of the vigilance officer, that is Inspector of Police CID. For the sake of repetition, it may be mentioned that the state level inquiry, while passing the impugned speaking order dated 26/2/20, did not objectively consider the inquiry report of the vigilance officer, which was mandatory requirement as per the guidelines of the laid down by the Honorable Supreme Court in the case of Kumari Madhuri. A perusal of the speaking order would reveal that the scrutiny committee, though referred to the report submitted by the Superintendent of Police Assam, but thereafter no discussion whatsoever was made to the findings of the inspector's report in the speaking order. On the contrary, while coming to the conclusion, the respondent writ petitioner was not entitled to the benefit of OBC, the scrutiny committee relied upon a parallel report which got conducted through the circle officer Jorhat Revenue Circle. Apparently, in terms of judgment of Madhuri Patil, the circle officer has no jurisdiction to carry out such inquiry. So that is why the government got stuck. That how come two different opinions are coming up from the same facts? That is why government delved into the depth to find out what is the truth, actual truth. Furthermore, the finding recorded in the speaking order that mother of Monsoon Borkakoti obtained caste certificate belonging to post certificate in the year 2019. The Honorable Court also recorded this. Is also an extraneous and irrelevant observations because, as has been referred to the service record, Srimati Purnima Dr. Mother of Respondent, her caste certificate is mentioned as coach OBC. So the official record mentioned without that certificate. She was working for 20 years prior to 2019. Testing the report of vigilance officer, the inspector CID on the touchstone of the principle of Madhuri Patil, we find that the inquiry report submitted by the CID does not indicate even in the slightest that the particulars given by the candidates were false or that the social status certificate had been fraudulently obtained. Thus, in view of the first report dated so-and-so, in case the report is in favor of the candidate and found to be genuine, no further actions needs to be taken. This is the principle of the Madhuri Patil. No further action is called for in the present case. So, coming to the next page. So, may I continue, Lord?
Yes.
However, the SLEC got another parallel inquiry conducted through Circle Officer Jorhat, who apparently has no jurisdiction to carry out such inquiry as indicated above. Another significant fact which needs to be noticed is that as the report of the Inspector CID, which was submitted after conducting the thorough inquiry in terms of Madhuri Patil, did not give any indication that the social status certificate was obtained by respondent by providing any false or fraudulent information. In fact, no information was submitted. Rather concluded that the social status certificate was validly and lawfully obtained. The authorities has no option but to accept the report and affirm the social status certificate of the respondent as per the guidelines contained in Madhuri Patil. Hence, the contrary conclusion drawn by the state level scrutiny committee is absolutely illegal and unwarranted. Under those facts, it was a correct judgment, Lord, in my humble submission. Now, when government restarted the inquiry and found out some very important and vital facts, now in that situation, what is the course open for the government and also to this for this honorable court? So these two judgments in my humble submission will be applicable on the facts which were there and in existence.
Can we quickly again go back to the scrutiny committee report?
Yes.
That is in
Page 96 of the report. May I read, Lordship?
Yeah.
Whereas a complaint received from Anti-Corruption Liberation Union, Jorhat, Assam.
We just need to find out the reasons. The
reason.
conclusion.
Next page. SLEC carefully examined all the above mentioned facts and documents and examined the guidelines issued regarding caste status of offspring of inter-caste marriage and also to reference to various judgments of Honorable Supreme Court regarding caste status of offspring of inter-caste marriage between tribal and non-tribal, SC and non-SC, OBC and non-OBC, made the following observations. Dr. Santanu Borkakoti, father of Monsoon Borkakoti, belongs to general category. Dr. Santanu Borkakoti is a medical doctor appointed to Class 1 cadre of Health and Family Welfare Department. As per gradation list issued by the Health and Family Welfare Department, as per gradation issued by so-and-so, Dr. Santanu Borkakoti belongs to general category. Purnima Dr. Borkakoti, mother of Monsoon Borkakoti, who claims to belongs to OBC, has obtained the caste certificate only in the year 2019, as per caste certificate issued by All Assam Backward Association dated 6/9/2019. The main objective of providing reservation to remove disadvantaged sufferings and restriction to which members of SC, ST and OBC are subjected, and also to bring them to mainstream by providing opportunities and facilities. Honorable Supreme Court has therefore held that scheduled caste and scheduled tribe certificate is not a bounty to be distributed In order to sustain the claim, one must show that he or she suffered disabilities socially, economically, and educationally cumulatively. The concerned authorities before whom such claim is made is duty bound to satisfy itself that the applicant suffered disabilities socially, economically, and educationally before such certificate is issued. Any such authorities issuing such certificate in a routine manner would be committing the dereliction of constitutional duty. The committee examined the claim Srimati Monsoon Borkakoti belonging to OBC on the ground that she was born and brought up in the parental home of her mother. Now here they used the parental home. The police officer said she was maternal home of her mother, who belongs to Koch community and largely accustomed to the culture of Koch community. Srimati Borkakoti in her written statement has admitted that she was born and brought up in Jorhat Town Club area, which is a urban locality under Jorhat municipal area having cosmopolitan culture. Srimati Monsoon Borkakoti has passed HSLC in the year 2007 and obtained OBC certificate in the year 2006 on the criteria of adopting the customs and traditions of her mother. But it is evident that her mother obtained the caste certificate only on 6/11/2019. It gives reasons of doubt as to how Srimati Monsoon Borkakoti obtained her OBC caste certificate in the year 2006, whereas her mother obtained her caste certificate in 2019. In the letter dated 5/1/2019, addressed to the Assistant Commissioner or Deputy Commissioner, the Circle Officer, Jorhat Revenue Circle, had mentioned in the context of verifying the authenticity of caste certificate of Monsoon Borkakoti, he had visited the residence of the incumbent accompanied by Papuri Das, Assistant Commissioner, Office of the Deputy Commissioner, and Gaonbura, Government Gaonbura. During the process of inquiry, both the parents of the incumbents were present. This inquiry is by circle officer. But both the parents of the incumbents were present. So this is directly in conflict with the opinion of the police officer, CID. Both the parents of the incumbents were present but failed to produce any caste certificate supporting their claim. Therefore, Lordship, the mother also applied in the month of November. And father also applied. Relatives' caste certificate are very crucial for assessing this kind of situations. In the report submitted by the concerned Lat Mondal as well as the government Gaonbura, Sekonidhara Gaon number 3 town, it is properly reflected that the family of the incumbent could not produce any caste certificate supporting their claim. From records available, it is seen that mother of Monsoon Borkakoti obtained the caste certificate as belonging to Koch community in the year 2019 on 6/11/2019, which makes it evident that prior to the visit of the inquiry team, Srimati Purnima Dotto Borkakoti did not have a OBC caste certificate. The visit of the inquiry officer perhaps prompted her to obtain one. OBC is a collective term adopted by the government to classify castes that are educationally, socially, and backward. So unlike scheduled tribes and scheduled castes, where the yardstick for recognizing or identifying them are distinct criteria for determining OBC, are social and economic backwardness in Assam, there is hardly any difference of culture of Koch community with that of the culture, customs, and traditions of other general communities. Hence, the ground of adoption of customs, religious act, and tradition of Koch community is not a valid criteria for issuance of OBC to non-Koch community person. The OBC community in Assam do not suffer any social disadvantage, rather are economically backward compared to the general communities in Assam. In case of Monsoon Borkakoti, as stated by her, her mother has been living in her parental home after marriage with Dr. Borkakoti, as their marriage being an intercaste marriage. The parents of Santanu Borkakoti did not accept her as their daughter-in-law and never stayed with their family, with their father. However, during inquiry, it has been found that she and her mothers were never abandoned by her father. Her father, Dr. Santanu Borkakoti, has been working in health and family welfare department and posted mostly in adjacent districts of Jorhat and Golaghat. Her mother is also government employee of irrigation department, and hence she has continued to stay in Jorhat because of her job. Mother is posted in Jorhat. Srimati Monsoon Borkakoti has passed her high school leaving certificate from Don Bosco School, Lichubari, one of the premier educational institutions in Jorhat. both her parents being government employees and lived in an urban locality in Jorhat, to have not suffered any disadvantage socially and economically. College part is left out here also, Lord. Under the facts and circumstances above and after proper introspection,
Circle officer is not a notified authority.
he is not authority, but they have this.
I just
No. One thing is another aspect.
See,
One is one report of the vigilance officer.
no. The Madhuri part,
Lord.
they are required to notify
Yes.
the authorities. So under that notification, is the circle officer is also.
No, it is not. It is not. Because Madhuri Patil's case, it is very clearly stated that vigilance officer, there should be a scrutiny committee, a vigilance committee. But this inquiry committee, this state level scrutiny committee, they are also trying to find out the facts. Now, in the so-called notice, when they will be issued, the evidence will be laid before them, not before the vigilance officer or any other authority, but before the state level inquiry committee.
Yeah.
So, under the facts and circumstances above and proper introspection and observation, the SLEC is of the view that Monsoon Borkakoti, daughter of Dr. Santanu Borkakoti and Srimati Purnima Dr. Borkakoti, resident of Clubhouse Jorhat, has obtained the caste certificate through unfair means by projecting a picture of having suffered deprivation, humiliation, disabilities, and handicap, which is very different from the reality. Hence, the OBC certificate issued to her should be cancelled by the appropriate authority with immediate effect.
Yeah.
So, the division bench as well as the single judge was pleased to look into the report, and they have rightly accepted the report. The government also accepted the report.
Somebody filed the complaint.
Yes.
It was inquired into by notified inquiry officer. He had given some report. Placed before the SLSC. SLSC declined to accept. And there was a parallel inquiry done by the circle.
That is also not required, Lordship. The SLEC straightway can
From the facts of the case.
From the facts.
Circle officer's report was relied upon. Then they came to the conclusion against the petition. It was challenged. View of the single judge is that inquiry officer's report not objectively
Yes.
interfered, appeal. So now you are trying to reopen this by one of those notified inquiry officers.
No, earlier also it was a notified officer. When he was done, it was properly done in respect of the vigilance officer.
Vigilance officer had done it.
Yes.
Now, on the grounds that because of certain inputs that you have got, that it is a fake or
Whatever.
fraudulent or fraud certificate or document, you are now trying to reopen it by way of the separate inquiry.
Lordship.
By notified. And you have issued a show cause.
Yes. After we are convinced that the facts which were unearthed during the subsequent inquiry are totally not considered in the first round of inquiry. And these facts and the ground realities are very crucial from the point of view of whether the writ petitioner is entitled to a OBC certificate or not. According to us, if all the facts are correct and it was correctly found out, then she has no case to get a OBC certificate. But we cannot straightaway reject her certificate also. So therefore, we have to give her an opportunity to defend her situation. So that opportunity is been given. Now, is there any bar in doing that? That is the critical question before this honorable.
Ordinarily, yes.
But ordinarily, yes.
Unless there is fraud or forgery.
Yes, that is very much evident now. It is as crystal clear as it can, the maximum at the highest level.
Now, who establishes? There has to be some finding.
That finding is there. Finding is of that 26th December's report. The finding is there. But whether that finding can straightaway be accepted by the government before taking a corrective step, or whether she should be given an opportunity to give her opinion, give her response for the basic reason of complying with the principle of natural justice. We have come to a conclusion that let us read the last line of that report. With 285, Lordship will kindly come.
In my opinion.
281, it starts submission of inquiry report.
Yes.
26th December 2023. The Joint Secretary submission of inquiry report of caste certificate, so and so. So the inquiry report from 282 it starts. So there are a lot of references at top. How the inquiry officer was appointed, everything was done. All the facts are stated. And finally, page 286, the opinion. Therefore, Srimati Monsoon Borkakoti is not entitled to claim the benefit of OBC as her father belongs to general category. Parents were never separated and she received all kind of support from her father. So this is the finding. So when we got this finding on the basis of materials which is stated from 282 to 286, all the facts, including the central government guidelines, Supreme Court judgments, the ground realities, the factual.
Who issued the show cause?
The authority, the state level inquiry committee.
SLSC, scrutiny committee.
Yes. SLSC is the authority under the Madhuri Patil's guidelines. And on the basis of this guideline, we have framed the OM also. In Maharashtra, a legislation has been enacted. And rules are also being framed in Maharashtra.
So OM lays down the procedure.
Which lays down the procedure. We have that OM of 2018, which is also a part of the records.
Yes.
So this is the opinion. So when this opinion is given to us, so what is the next course of action? The next course of action is to issue the show cause notice and take a proper hearing. Now this district level, this state level scrutiny committee, they will hear both sides of the story and find a final opinion. If they can convince them that the findings of this is not tenable, she will still continue to have the OBC certificate. If it is on the reverse, then this authority, this state level inquiry committee will give an opinion and recommendation for cancelling her certificate, which the deputy commissioner subsequently have to issue a cancellation certificate. So, in what situation we can go for a fresh inquiry? That J. Citra's case.
Can we have a look at that OM?
Yes.
OM?
OM from there. Okay, you know. $275. 11th May 2018.
Yes.
In pursuance of the office member, in pursuance of the directive of Honorable Supreme Court in Kumari Madhuri Patil, the state government has decided to create vigilance cell at the directorate level and issue modalities of its functioning. Accordingly, the following instructions are issued for further simplification of the procedure of dealing with matters relating to fake caste certificates. Vigilance cells are to be constituted at each of the directorate, that is the Director of Welfare of Plain Tribes and Backward Classes and Directorate of Welfare of Scheduled Castes, consisting of Deputy Superintendent of Police CID with such number of police inspectors as required to be investigate into the social status claim of Scheduled Caste and Scheduled Tribe candidates. Superintendent of Police CID shall supervise the functioning of the vigilance cells. The vigilance cells shall function under the control of state level scrutiny committee. So here we find the state level inquiry. Then all the procedures are given here, including show cause notice, etc. May I,
Yes.
I can continue. On receipt of the reference, the inspector who will be designated as the vigilance officer shall go to the local place of residence and original place from which the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. So he did not visit Silpukhuri or Guwahati also, the first of. The vigilance officer should personally verify and collect all the facts of the social status. These facts he did not collect. He gave opinion on the basis of Supreme Court pronouncement. Claim by the candidates or the parents or guardians as the case may be. He should also examine the school records, birth registration, if any. He should also examine the parents, guardians, or the candidates in relation of their caste or such other persons who have knowledge of the social status of the candidate, and then submit a report to the concerned directorate together with all particulars as envisaged in the proforma. In particular,
Yeah.
of the scheduled caste tribes relating to their peculiar anthropological and ethnological traits, deities, rituals, customs, mode of marriage, date, ceremonies, method of burial of dead bodies, etc., by the caste of tribes, communities concerned. The director concerned on receipt of the report from the vigilance officer, if found that the claim of social status is found to be not genuine or doubtful or spurious or falsity or wrongly claimed, the director concerned should issue so cause notice. This is what we have done. Notifying, supplying a copy of the report of the vigilance officer to the candidate by a registered post with acknowledgement due or through the head of the educational institutions concerned in which the candidate is studying or employed. The notice should indicate that the representation or reply, if any, would be made within 2 weeks from the date of the receipt of the notice. In no case, only a receipt of request more than 30 days shall be granted from the date of receipt of the notice. In case the candidate seeks an opportunity for hearing and request that an inquiry to be made in that behalf, the director on receipt of such representation shall convene the state level scrutiny committee and the secretary as chairman, who shall give reasonable opportunity to the candidate parents and guardians to adduce all evidence in support of their claim. So if director has issued, and if they want to go for a proper hearing, then the whole committee will sit. A public notice may be published in the village or locality, and if any person or association opposes such a claim, an opportunity to adduce evidence may be given to him. After giving such opportunity either in person or through counsel, the committee make such inquiry as it deem expedient and consider the claims vis-a-vis the objections raised by the candidate or opponent and pass an appropriate order with brief reasons in support thereof. In case the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken, and except where the report in the particular given or procurer found to be false or fraudulently obtained. In the latter event, the same procedure is envisaged in paragraph 2 be followed. If the report is in their favor, Lordship, their enquiry is not required at all. This is what Madhuri said, and the division bench also followed in our case. Notice contemplated under paragraph 2 and 3 should be issued to the parents, guardians, also in case the candidate is a minor, to appear before the committee with all evidences in his or her their support of the claim for social status. The inquiry should be completed as expeditious as possible, preferably by day-to-day proceedings. Within such period, not exceeding 2 months, if the inquiry, the state level committee finds the claim to be false or spurious, they should pass an order cancelling the certificate issued and confiscate the same. The state level inquiry committee, scrutiny committee, should communicate within 1 month from the date of conclusion of the proceedings the results of the inquiry to the parents, guardians, and the applicant. In case of any delay in finalizing the proceedings, and in the meantime, the last date for admission to an educational institution, this is not applicable. Next slide. In case the certificate obtained or social status claim is found to be false, the parent guardian candidate should be prosecuted for making false claim. If the prosecution ends in a conviction and the accused is sentenced, it could be regarded as an offense involving moral turpitude, disqualification for elective posts or offices under the state or the union, or elections to any social body, legislature, or parliament. As soon as the finding is recorded by the state level scrutiny committee holding that the certificate obtained was false, it should be simultaneously cancelled and confiscated, and the same shall be communicated to the educational institution concerned order appointing authority by registered post with acknowledgement due with a request to cancel the admission or the appointment. The principal, etc. of the educational institution responsible for making the admission or the appointing authority shall cancel the admission appointment without any further notice to the candidate and debar the candidate from further study or continue in office in a post. The order passed by the committee shall be final and conclusive, subject to proceedings under Article 226 of the Constitution. So this is the detailed procedure. And next page, Lordship will see page 277. The vigilance cell. In 2006-2019, the vigilance cell was constituted. Director, WPT is the chairman, deputy director is a member secretary, deputy SP of police, CID member, inspector, police 2 numbers, they are members nominated by SP CID. So Dibbojyoti Dutta entered to serial number 4. And next page, Lordship, 24/6/2019. These are the 2 inspectors who were appointed, nominated. Inspector Jodu Malakar, Inspector Dibbojyoti Dutta, and Deputy SP Satkokal Sanction. Then this gentleman was given the responsibility to inquire. Page 280. To Dibbojyoti Dutta, verification of caste certificate. 3 cases were given to him. One is Monsoon Borkakoti, next is Vicky Patel. This is MBBS case, Lordship, and Hussein Ahmed.
Yes.
So now Dibbojyoti Dutta is facing suspension and departmental proceedings. And so far as the father of the lady is concerned, the petitioner, we have filed the additional affidavit where we have stated all the discrepancies, all the misdeeds of him. Paragraph 4, very long paragraph. What he has done, we have narrated everything. Paragraph 4, page 376. Everything is described and elaborated here. And page 380, last subpara of that paragraph 5, paragraph 4. After investigation, Inspector Arbil Hojai, Inspector Investigating Officer of the case, have filed charge sheet in the case registered under section 120B, 420, 468, 471 IPC, filed CID PS charge sheet number 1/2025, dated 21/1/2025, against accused Santanu Borkakoti, son of so and Surendranath Bora, son of so and so. He was the Gaubura who was in hand in glove with Borkakoti to issue that certificate. So the trial will start very soon. He is on bail, and the Dibbojyoti Dutta, the vigilance officer in the earlier round, Lordship, he is also was under suspension, and he is now facing the departmental proceeding which is going on. Whole endeavor of the state government is to, Lordship, root out any foul play in the procurement of SC/SC certificate, and no genuine candidate is deprived from the benefits which is given under the Constitution of India. So that is basically all the facts. If Lordship allows me tomorrow or maybe on Tuesday to complete my submissions with the judgments, it will also take some time.
Really? I thought you'll conclude today. No.
It will be very difficult. It will take another 1.5 hours to 2 hours. How the Supreme Court has dealt with this kind of situation, and what should be the actual way of looking forward and taking the course in granting and well examining also the validity of caste certificate.
All right.
I do not want to leave any stone unturned in my efforts in this case, Lord.
So we were
Today,
in the first round, earlier round, just thinking whether it would have been better for you to file a review against the order of the division bench.
no, we have filed it. Now the division bench said, if you follow, ultimately we have to fall back to the same procedure. That is why whatever is fallen from Lordship's mouth, we have also thought on the same line. Then the Honorable Division Bench said, after doing the review, again, you will go back to the scores as given in the OM of 2018, that issue of show cause notice, etc. So that will be a redundant exercise. That is why we took a conscious decision not to go further, because those judgments were correct in the facts and circumstances as prevailing at that point of time. Now the facts and circumstances have changed and changed drastically. So I don't think this is a case of res judicata.
No, not res judicata, but res judicata.
Now, basically, they are
Whether-
trying to.
whether the question of judicial propriety
Absolutely.
is an issue to be.
Yes. Now, this is
Which
what
they
they,
got
according to them, the issue is already closed by the division bench. So there is no scope for opening it before this honorable court at this stage. No, in my humble submission, no. The facts are totally different.
All right, we'll continue on Tuesday.
Lots. Highly obliged.
Mr. Vargas. Okay, that is- Come. Right. Brother, the argument of the hearing on Tuesday. Mr. Nath, this is the learned advocate. And we just, with another matter, since Mr. Nath is there, the departmental proceeding, it asks for the records, at least an information as to what is the status of the appeal.
I'll get the information. At two, I'll
You see if you can get the information.
I'm told.
Second half will go.
Last occasion, my lord asked me to hand over the judgment of limitation. So I had handed over. Gentleman knows what he has to do now.
I will reply to.
Yes.
It was 2 days only, your lordship, 2 days.
My lord. Yes, exactly. Well, that can be decided before the arbitrator. He also have a then wider angle. Then the other contesting party also can present this question. Madam Devi was there. These points can be very well argued before the arbitrator. Morning, morning I was on legs, my lord. Yes. Yes, that can be done, but if lordship is willing to pass any orders in her absence, then lordship can list it on tomorrow, Monday. I'll call her to be inadvertently present. Lordship can take it as a first item, dispose it off. Yes, I'll try. I'll try. Obliged.
Lordship, I think Mr. Nath has got some input. He suddenly had to go to court number 17. 11th.
Matter pertaining to my selection of IT technician. After the extended date, 2 months, again, because lawsuit at least call for the records to see whether only the private respondents and the beneficiary section is implemented.
But we have already filed affidavit stating that the last date of submission of application was extended. That flag mark is that notice matter. Yes, my lord. It is not that, it's my lord, whether extension was done or not, my lord. Because it is not, because some additional posts were there, so it has been decided to include those posts, thereby extending this, my lord. Yes, my lord. Yes, my lord, from record. Yes. My lord, the issue is that, my lord. No, I can put it the record. Hello, it is also part of the record, my lord. I can produce the, I can call for the original record, but the issue is that, my lord, whether the private respondents were eligible on the last. My lord, on last date, I submitted that records are on the way. I did not receive on last. Oh. Yes, my lord. I have called for, but they have provided me with this. No, my lord, I can call and they will provide, my lord. Your lordship may indicate that original records may be produced, my lord. Yes, my lord, I understand. Yes.
Extension of the last date of submission of application. the post of IQ technician.
Tuesday, my lord, on my lord, uh, well, my lord, it will not be possible, my lord, on 16th or any day after 16, my lord. Yes, my lord, 17th.
Six. Okay, that's the number. Six. My phone.
Deeply rooted.
Yes, my lord. I was terminated on 26/5/2009. I was appointed on 28/3/1989. My date of termination, my lord. My lord, I am praying here in this writ petition for release of my pensionary benefits, which I have been denied. My lord, the order, my lord, is at page 21. Page 21, my lord. It is reflected in bold, my lord. Removed from service with superannuation benefits, that is pension and or provident fund and gratuity as would be due otherwise under the rules or regulations prevailing at the relevant time and without disqualification from future employment. Yes, my lord. I had filed an appeal, my lord. The appeal is at page, the order of the appeal is at page 22. Order dated 28/8/2009. Yes, ma'am. Now, my lord, the issue is that I have not been paid my pensionary benefits after my termination. Now, as I understand, my lord, the ground which has been taken by the State Bank of India is that I have not completed 20 years of service with the bank. Now, if your lordship may kindly come to page 21, again, my lord, the order of termination. Page 21. Subpoint 4, point 4, my lord, the suspension period is to be treated as not on duty. However, the subsistence allowance drawn during the suspension period need not be recovered from the charge sheeted employee. My submission as of now, my lord, is that up till the date of my termination, the termination order, my lord, is prospective. It does not go back to my date of suspension. And I was paid subsistence allowance by the bank till my date of termination. And my date of termination, my lord, would indicate that there was an employer-employee relationship existing and prevailing at that point in time. And thereby, my lord, by that logic and rationale, my lord, I have completed 20 years of service and I ought to be paid my pension. That is my submission, my lord. The facts are admitted, timelines are admitted, my lord. that is my submission. The authorities have appended the SBI employees pension fund rules, but that is for them to argue on that. But my submission as of now, my lord, is that I've completed 20 years of service with the bank in an employee-employee relationship arrangement, and by that logic, my lord, I ought to be paid the pension as per the rules applicable at that point in time. The rules, my lord, are in the affidavit in opposition, which has been filed by my senior friend.
Space 63, my lord, relevant to 22
Yeah.
of my affidavit in opposition. Right? Married, my lord. A member shall be entitled to a pension under these rules on retiring from the bank service after having completed 20 years pensionable service, provided that he has attained the age of 50 years or if he is in the service of the bank on or after 1/11/93, after having completed 10 years pensionable service, provided he has attained the age of 50 years or if he is in the service of the bank on or after 22/5/96, after having completed 10 years pensionable service, provided that he has attained the age of 60 years. After having completed number B, after having completed 20 years pensionable service, irrespective of the age he shall have attained, if he satisfies the authority competent to sanction his retirement by approved medical certificate or otherwise that he is incapacitated for further active service. C. After having completed 20 years pensionable service, irrespective of the age he shall have attained at his request in writing. After 20 years pensionable service, 25 years pensionable service. Number 2. Close to a member who has attained the age of 55 years or who shall be proved to the satisfaction of the authority empowered to sanction his retirement to be permanently incapacitated. So, under none of this B is on medical incapacitated condition. Number C will come into picture only when he has opted for voluntary retirement or in writing from the retirement from the service. In the present case, my lord, he has been dismissed from service, as he has, my learned friend has pointed out, and the qualifying words are that page 21 of their writ petition, my lord. Yes, my lord. Disciplinary authority does not say that pension has to be paid. The qualifying words under the bracket, my lord, has to be given importance. Removed from service with superannuation benefits, that is pension and or provident fund and gratuity, as would be due otherwise, under the rules or regulations prevailing at the relevant time, and without disqualification from future employment. This is number one. From future employment, he is not disqualified. Now, clause B4. This is also important. The suspension period is to be treated as not on duty. This is important, my lord, because had this been challenged and this been removed, and this is the order of the disciplinary authority, and page 22 is the of the appellate authority which has upheld it against the decision of the discipline. He was
1 year, 2 months.
He was
1 year, 2 months.
Yes, my lord. And that has not been challenged. And this order of the disciplinary authority and the appellate authority has been put to challenge in the writ petition. That is by order dated 22/18 has been upheld. My lord, page Annexure 6, page 24 of the writ petition. And relevant portion of the order is at page 27. Para 17 is the concluding part. However, if the delinquent has not received his superannuation dues as was ordered by the disciplinary authority, notwithstanding the dismissal of this case, the respondents must ensure that all superannuation dues in terms of the impugned order dated 26/5/2009 be disbursed to the delinquent within 8 weeks from the date of receipt of this order. And this 26/5/9 order as page 21 clearly reflects that the period under suspension shall not be treated on duty. Again, this was never agitated before the disciplinary authority when the order was passed, not before the appellate authority, and neither before the honorable single judge when this writ petition, both the orders were challenged before this honorable court. Now, as per rules, it is mandatory that not having 20 years of completed service, he is not entitled for pension. Other pensionary benefits has been disbursed, the gratuity fund and all, except the pension since he is not been found entitled under the rules. So there is no infirmity, my lord, in rejecting his pension part only.
My lord, I'll request the lordship to come to page 63 once again. 22, subclause 1, subclause C. After having completed 20 years pensionable service, irrespective of the age, he shall have attained his request in writing. My lord, the word here is not service, the word is pensionable service. And when I go into the definition of what pensionable service constitutes under the rules, my lord, I find that pensionable service has not been defined. In this regard, my lord, I had generally researched and I understand that no, my lord, no, my lord. There is a slight difference, my subject to correction, my lord. Pensionable service has been defined is in the Employees Pension Scheme of 1995. The word pensionable service, my lord, is defined as means the service rendered by the member for which contributions have been received or are receivable. In this, yes, madam. No, in fact, it was given and things were, my lord, there was certain amount of post-tal benefits which were granted to me, not pension, which were adjusted against other recovery amounts. So as of now, I do not hold a single penny out of my employment tenure with the bank. But be that as it may, my lord, I'll beg your lordship's attention at page 45 of the affidavit. Page 45, it's a continuation of paragraph number 6 at page 44. The submission is a replication of my senior friend's submission that the order of the disciplinary authority dated 26/5/2009 is quoted herein below. Removed from service with superannuation benefits, that is pension and/or provident fund and gratuity as would be due otherwise, under the rules or regulations prevailing at the relevant time and without disqualification from future employment. It was further ordered that the suspension period is to be treated as not on duty. This is not disputed, my lord. However, the subsistence allowance drawn during the suspension period not to be recovered from the charge sheeted employee. Hence, the letter dated 12/3/2018 of the petitioner demanding to prove superannuation benefits of his service with pension is misdirected and based on erroneous interpretation of order passed by the disciplinary authority, order dated so and so. Now, my lord will kindly come to 5 lines below. It is pertinent to mention that at the relevant time, the State Bank of India Employees Pension Fund Rules 1955 was in force, and in terms thereof, the petitioner was found ineligible for pension. However, now this is very important, my lord. However, other superannuation benefits like provident fund and gratuity were released to the petitioner after adjustment towards liquidation of his loan account. Towards provident fund refund, an amount of rupees 7,56,000 so and so was received by the PPG department LHO Guwahati as payment of provident fund to the petitioner, out of which so and so has been adjusted towards liquidation of his loan amount, and the balance of so and so was refunded to the central office as accrued interest. Similarly, an amount of so and so was received by the PPG and gratuity department LHO. What I'm trying to say, my lord, is that whether assuming that the petitioner, not assuming, my lord, it's given that the petitioner was not in rendering service while he was suspended. If pension contribution was taken for him during the year of 2009, that will qualify as the pensionable period, not as the period which has been interpreted, subject to correction, by the State Bank of India, saying that he has not been in service. Not being in service, my lord? No, in fact, I've been going through the matter. I think the entire crux of the matter, subject to your lordship's observation, my lord, may finally fall in the fact that whether pension was recovered or pension was contributed from the petitioner in the year 2009. If that information is given, my lord, then the pensionable service. Exactly. In fact, my lord, I'll have to go through the matter again. The issue is it's on a very narrow campus, my lord. Whether he had rendered, whether I do not have the instruction, my lord. No, in fact, my lord, I just want to press my point here that the entire service period and the pensionable period are different, my lord. They're fundamentally different, my lord. Your lordship will give me I made my contribution was taken from me, my lord.
Ah.
Yes.
Then
so that
what has happened to that?
That had been given to me, which was adjusted against other outstanding amount, my
gratuity and all. Some adjustments have been made.
Some adjustment. In fact, I had not received any substantial amount, but I'm not disputing on that, my lord. But the payments which were released to me, those payments were adjusted against other liabilities with the bank and the loan account. So I'm pressing here only for the pensionary release of the amount, my lord.
There was already a direction in the earlier round that your pension should be disbursed within 8 weeks.
Yes, my lord. As per applicable rule.
Then
it was not done.
Not done. Did you file any contempt or anything?
No, my lord.
I'll see, my lord. Page 20, 31 and 32 of their writ petition. It is incorrect to say that he has nothing been.
No, he says it has been received, but you have adjusted it.
Yes, he has taken certain loan. There was a certain liability that has been, my lord, that has been adjusted. He cannot say that nothing has been disbursed.
I haven't said that. I haven't said that.
It was disbursed and it was
I haven't said that. I made a
1,38,000.
This is to certify that an amount of rupees 7,56,622 was received from State Bank of India Department, LHO Guwahati, as payment of Provident Fund refund of Sri Champak Bo Thakur, a resident of so and so, out of which 6,18,018 only has been adjusted towards liquidation of the loan account as mentioned below, and the balance amount of rupees 1,38,604 was refunded to central office as accrued interest. So nothing was left, so nothing has been given because against the pending loan, outstanding loan that has been adjusted. Now again in page 32, my lord, out of 2,70,531 towards the PPF and gratuity, that amount was also been.
Page number 33.
32, my lord.
Come to 33.
Yes, my lord. 33.
33.
This is the letter which they have impugned.
Right.
Because as per the rules, my humble submission is that as per the rules, he did not complete 20 years.
How many years has he completed?
He has completed 19 years. And the period of suspension will not be treated on duty. So he has only completed 19 years, whereas for eligibility of pension, it is 20 years. And my lord, kindly see annexure 10. What my learned friend is projecting the case in a different manner now, and what their main cause with annexure 10. It was relying upon one judgment of the Honorable Supreme Court that is pertaining to only the VRS. That would 22(1)(c) would come. This VRS, had it been opted in writing, VRS is a scheme in itself where proportionate pension, even after completion of 15 years, is payable. But for the regular pension, 20 years is the pensionable service. And he having not completed 20 years as on the date of suspension.
Where is this judgment?
Hello?
Where is this judgment that you have referred?
That I have given the 2020 volume 6, page 438. This is pertaining to VRS. This is not covered the regular pension. He has been dismissed from service and that has never been agitated. That has attained finality.
My lord, I'm merely submitting on the aspect of not service rendered, but pensionable service. That is my humble submission. The word used is pensionable service.
You interpret it, you show it to us.
Yes, my lord. Pensionable service has been defined in the Employment Provident Scheme, my lord. It says that any year for which contributions are received, if the authorities can show, I am not in service, I was not in service for 1 year and 2 months, I'm not disputing that, my lord. That is a part of the record. But while not being in service and whether a contribution was taken from me, there are two absolute different parameters. And that parameter is, the word is used, pensionable service. Pensionable service is not defined in the rule. My lord, that is my humble submission. Let
You had earlier come before this court.
Yes, my lord.
All these issues were not raised.
My lord, I'm raising it now,
You
my
are,
lord.
you are, how can you raise it now?
No, my lord.
You did not go in appeal against that order.
My lord, this.
Did you go in
No, my lord. The earlier writ petitions were regard to the disciplinary proceeding which had culminated, my lord. This petition, my lord, is subject to your lordship's observation. Is not barred by res judicata, my lord. This is for only release of my pensionary benefits, which I am entitled to as per my submission, because pensionable service, my lord.
Show us some authority. Please show us how, on what basis you have.
My lord, the authority. My lord, the
How are you
authority.
trying to interpret
My
it?
lord, the authority will be based on records which the bank will provide, whether contributions were received from me, or alternatively, my lord, even I can submit those records.
You should.
If I can show that contributions were taken from me in the year 2009, that will come as pensionable service.
You should have.
I should have, my lord. I do not have time, my lord. We'll fix the matter. That is the only crux what the matter is hinges, my lord. That whether contributions were taken from me in the year 2009, if it was taken, irrespective whether I was in service or not for 1 year or 2 years or 3 years.
Is there any information to that effect?
No, my lord, this.
That is for pensionable services, my lord. Not on duty.
Well,
Not...
yes, now given a new interpretation, this has not the pleaded case. Yes.
Many cases.
So you are saying that 20, it is a simple case that he has not completed 20 years and the period
Exactly,
under
my lord.
Let me complete.
Your application is with reference to a judgment.
And my lord, the judgment is here. It is, my lord, that is for VRS. But I'm pressing a point of law here, my lord. That pensionable service would amount to a service period where contributions were taken from me.
Was that contributions were made?
My lord, lordship will give me a short date to furnish those instructions, my lord. If contributions are taken from me in the year 2009, that will qualify as a pensionable year, my lord.
List in the month of July. That's very common.
No, when it is
July. You're not ready, you should ask for this.
No, my lord, that was my submission. In fact, my lord, I'm apologetic, my lord. The fact is, the bank should have ideally shown whether
you stand or fall on your own.
Contributions were recovered from me or not, my lord. That would mean the ground which has been taken by the bank is that I was not in service, my lord.
Submission, my lord. This earlier petition for appeal has been filed.
Before your lordship starts with the hearing, but in respect of item 4, I have got the instructions that the appeal is under consideration. And record lordship has fixed on 11/6, I will place.
You give us the status of the appeal.
Yes, and the record too.
Yes.
All right.
I will just take up one small matter.
Cosmo.
Right. See, this question of being time barred, etc., can be looked into by the arbitrator. Because there is no dispute that there is an arbitration clause, and in case of any differences, we'll refer it to arbitration. Whether it was properly issued, not issued, all these, we can raise this. But Sanjay Sharma, person, as well as the Goyal and the Python, and RTB, and the CC. He is the number. Let's see responses. Respond. The petitioner is power of attorney holder. What is the name of the person who gave you the power of attorney?
Yogesh Bhatti, the proprietor of the firm.
Yogesh
Bhatti, BHATI, Bhatti.
BB. It's a firm had entered into a contract, was granted work order by the who had Who had issued the order, work order?
Was CW Tejpur, your lord.
Under works engineer.
The acceptance was issued by CW Tejpur and work order by garrison engineer Tenga. That is their procedure, your lord.
Order will be issued by respondent. And accepted by the respondent. First when did the petitioner proceeded. You did not proceed with the tender.
We completed some part of it.
Proceeded with the tender, with some portion. Thereafter, the tender was terminated. The brief, the petitioner raised this issue before the respondent authority. So, referring to the agreement where there is an arbitration clause, the petitioner requested the respondents to appoint an arbitrator in the matter. So, the respondents having refused, you have refused to appoint.
Refuse lordship, the set of names were sent to them, lordship. They have not agreed to.
There was your lordship.
Furnished a set of names from the curated panel made by the respondent for appointment of arbitrator. The same was not accepted by the petitioner, and accordingly the petitioner by the respondent filed their objection to the matter and has questioned the issue of raised the issue of the matter being time part that that the notice under 21 was initially issued by the power of attorney holder. He was not authorized to do so, as the power of attorney was issued on a subsequent date. So therefore, the petitioner, the respondent submit that there was no proper notice. What clause is that?
Condition 70, your lordship.
70.
70.
Yeah. It's now me.
It is a legal issue, so I would request to appoint Mr. M. K. Bhattacharya, Mandan Kumar Bhattacharya.
I think that appointed I
That's
by
June.
the next day, party will communicate for court. With completely communicate for either again or
By June.
June.
June, you said I will.
23rd. 23rd?
Yes.
19th day, party will declaration that may by perspective are as well as the will right the order confirming the past result.
Thank you.
What is the issue here?
Well, this petition comes up before your lordships, not for consideration of the prayers, which I'll presently request your lordships to peruse in light of a very peculiar set of circumstances in my humble submission. Well, I'll just first, my lord, if your lordships kindly permit me, give a brief outline of what the matter is and how it arises, and then, my lord, come to the submissions. My lord, in the year 2004, the state legislature of
But I must put you to notice we'll rise by 350. We'll have to rise.
entirely in your lordship's hand, my lord. The only thing is, my lord, then if your lordships may be pleased to treat it as parted and have it on some other day, or my lord.
We can keep it on
But-
some other day. We gave you the option.
I tell your lordship, my lord, why it's, my lord, working so harsh, my lord, and is only as a ground of urgency. My lord, these persons, my lord, very briefly, there was an act in 2004. This was an act of the legislature of the state which designed, my lord, a specific course for persons, my lord, who were supposed to join that course after a proper selection on merits, my lord, undergo that course, and, my lord, if found successful on completion of the course, were handed over, my lord, a diploma in, my lord, medicine and rural health care. This was the act of the legislature of the state. The institution which imparted, my lord, education was a government institution at Johra, the medical institution at Johra.
Hospital.
Yes, my lord. There are no private entities concerned with this. My lord,
Only in Jorhat.
only in Johra. My lord, there was power under the act which was reserved, my lord, for the purpose of notifying other institutions. The selection procedure was by way of, my lord, inviting applications from each district. For the reason being, my lord, on account of peculiar geographical, my lord, area with which we are concerned in this state, my lord, the state government felt, and therefore the legislature of the state took upon itself to frame a law that, my lord, certain attention needs to be given for rural health care. There were, my lord, areas which were far remote where, my lord, medical help of basic requirements or basic necessities of medical health were not available. So this act was challenged by, my lord, the Assam branch of, my lord, the Medical Doctors Association. My lord, during the process, applications, there was no stay. We were not parties to that litigation. My lord, applications were invited by the state from each district year after year, and, my lord, that's how, my lord, there are 609 petitions. My lord, batches 1 to 6, which covers, my lord, approximately about 462 people, my lord. Only lordship need not, for the time being, trouble your lordship with the papers, my lord. I'm only giving a brief. I'll take your lordship to each document, my lord.
Yes, yes.
For about 450 or odd of them, my lord, completed the course. They were, my lord, handed over diplomas. They were, my lord, employed by the state government.
Yes.
The other batches were in the pipeline, meaning, my lord, it was a 3-year course of study and 6 months of internship. Totally about 4 years, my lord. So they were studying. Well, comes a decision of this Honorable Court on 30-10-2014. That the Act is repugnant to Section 10A of the Indian Medicine Act on the ground that the provision for either recognizing a new medical degree or a course or starting a new course, the powers are vested only under Section 10A, which is a central legislation in the Medical Council of India. The matter was, there was an application for the purpose of impleading persons who had already, this court dismissed that application. The matter stood there. There was no relief which was granted so as to annul. That's my respectful submission, and I'll take your lordships to the record, which would annul the degrees which were already confirmed. But students who were in the midstream of their education went before the Honorable Supreme Court challenging the judgment of the division bench of this Honorable Court. Joined with them were certain persons who had already been conferred diploma. In the meantime, to remedy the situation, the state came out with another legislation which is of the year 2015. And instead of designating them as rural health practitioners who were designated as such, and I must tell your lordship that there were a lot of restrictions under the 2004 Act, namely that they will not either prefix or suffix doctor. So normal man, a citizen of this state or country is not misled. They will not practice other than what was permissible. It was a restricted practice, restricted to the education which was imparted to them. They will not carry out any invasive surgery. They will not carry out a large number of restrictions followed by penalty and prosecution clauses. And their practice in this truncated form after being duly qualified as a diploma holder was restricted only to rural areas. No area in a municipal or an urban area was permitted to be practiced by these people. So the matter went up to the Honorable Supreme Court in the year 2015. There was a challenge laid to the 2015 Act by all those persons who had obtained degrees before this Honorable. That matter was transferred by an order of the Honorable Supreme Court and withdrawn to the Lordships of the Honorable Supreme Court for a decision along with the pending civil appeals or the appeal arising from the judgment of this Honorable. They were simultaneously decided. The Act of 2015 will upheld. One particular very important direction is, while considering the Act of 2015, the Honorable Supreme Court held that that Act is perfectly valid. It doesn't impinge upon either legislative competence. They have removed the basis of the judgment. And the observation in my humble submission is in paragraph 25 within bracket small Roman 4 that all those persons, the Assam Act is defined under the judgment in paragraph 2 to mean the Assam Rural Health Regulatory Authority Act of 2004. So all those persons will be permitted to practice allopathy medicine as they were permitted under the Assam Act. So therefore, we made a representation after the judgment. After the judgment, we told the government that we are permitted, and our respectful submission is that the judgment in terms if read by this Honorable Court or even by the state authorities would mean that what had already been done is saved by the Honorable Supreme Court. Otherwise, in my humble and respectful submission,
So their diplomas, they had got it under 2004 Act.
2004 Act,
which was held to be bad.
Which was held to be by this Honorable Court as repugnant to Section 10A. That reasoning did not find favor with the Honorable Supreme Court. But the Honorable Supreme Court examined the challenge to the Act.
Subsequent Act?
No, the first Act, Self-Saved Act of 2004, on the ground that the state legislature lacked in legislative competence. Your lordships are aware. Entry 66 of List 1, authorizes the central government, or it's in the union list, where only the union parliament has the legislative competence to make any laws on certain areas which fall within the entry 66, which is laying down standards of education, etc. Entry 25 in the concurrent list, list 2, is a entry on which both the union parliament as well as the state legislature can enact Your lordships are well aware of the constitutional principles, my lord, Article 245, 251, and 254, which says, my lord, that my lord, both have power. To the extent, my lord, the State Act is repugnant to a union law, whether, my lord, made prior or thereafter, to that extent it is void.
2015 was also brought by the state.
Was also brought by the state to remedy the situation in view of the judgment. But what happened is, my lord, the rural health practitioners was a stage above. Well, they are sought to be downgraded to community health professionals, meaning, my lord, they have to, my lord, they become glorified nurses, my lord. My lord, they were all employed under the earlier, my lord, NRHM, the National Rural Health Mission.
Where were they employed?
But they were employed by the state, my lord.
No, what?
In rural areas, in, my lord, community health centers, which are, my lord, primary PHC, primary community health centers. What was HC was? Sub centers, and, my lord, all government under, but they were on contractual basis. Now, even after the judgment of the Honorable Supreme Court, my lord, as I have produced some, my lord, material which was available to us on correspondence, my lord, there was a proposal by the state to have a specific, my lord, post of rural health practitioners with particular, my lord, pay band, etc. That never got implemented, my lord. That's why we are before the, my lord, court. My lord, may I therefore, my lord, give a short list of dates which will put in chronological event, my lord, the facts that I have given a brief outline.
Now, in these proceedings, what is your prayer?
Yes, my lord, would your lordship oblige me and please have page number 127. The prayers are set out there.
Yes.
Am I with my lords, my lord? Paragraph 30, which starts at bottom of page 126. It is therefore most respectfully prayed that your lordships may graciously be pleased to admit this petition, which is done on 29th of January 2025. Call for records and issue rule calling upon respondents to show cause as to why. 1. A writ in the nature of mandamus shall not be issued directing respondents to notify the petitioners as allopathic practitioners in the manner as they were permitted under the Act of 2004 in the rural areas of the state of Assam in terms of paragraph 25 within bracket Paul Roman 4 of the judgment dated 24/1/2023 of the Honorable Apex Court passed in SLP number 32592-32593 of 2015, as well as transfer case civil number 24 of 2018 and transfer case civil number 25 of 2018. A writ in the nature of declaration shall not be issued declaring the present registration numbers of the petitioner, as indicated under Section C of the Assam Community Health Professionals Registration and Competency Act 2015. This is the full nomenclature of the 2015 Act. To mean to declare the petitioners as allopathic practitioners in terms of paragraph 25(4) of the judgment dated 24/1/2023 of the Honorable Apex Court in so and so in the matter of Darul Islam and others versus the Indian Medical Association and others, wherein it was observed and recognized the petitioners as allopathic practitioners and allowed to practice in the manner as they were permitted under the Act of 2004 through the Act of 2015. A writ in the nature of mandamus shall not be issued directing respondents to frame rules, regulation, and appropriate scheme in respect of the petitioners as allopathic practitioners in terms of paragraph 25(4) of the judgment dated so and so passed by the Honorable Supreme Court. A writ in the nature of mandamus shall not be issued directing respondents to establish a regulatory authority to regulate and register the petitioners as allopathic practitioners in terms of paragraph 25(4) of the judgment of Honorable Supreme Court. For this, your lordship may only mark that there is already, my lord, the State Medical Registration Act, my lord, of 1999, and this really may be or is liable to be considered under that provision. In the alternative as to why a writ in the nature of certiorari shall not be issued to quash or notice dated 6/8/2015, and a writ in the nature of mandamus shall not be issued directing respondents to provide petitioners a unique identity as allopathic practitioners as having been recognized by the Apex Court, and accordingly redesignate their post and provide for a separate scheme of registration under a state medical register in terms of the Assam Medical Act 1999. A writ in the nature of mandamus shall not be issued directing state respondents to formulate a scheme like a condensed MBBS course for the petitioners as one-time measures so as to continue and complete the studies to meet the standards of a recognized medical qualification as envisaged under the National Medical Commission Act of registered medical practitioner in case the respondents find the petitioners unfit for the above relief. A writ in the nature of mandamus shall not be issued directing respondents to create a permanent post as stipulated in terms of file number so and so for the petitioners, and thereby to create a separate cadre with payment and financial benefits, including basic pay, grade pay, medical allowance, and other financial benefits arising out of the state post, recognizing their identity and dignity, and on perusal of the record and interim relief. There cannot be an interim order, my lord, in the petition.
You are relying on this clause 4, page 513.
Yes, my lord.
That's the
Yes,
finding
my
of
lord.
the
The judgment starts at, my lord, page 376, my lord. Then, my lord, if your lordship will, my lord.
Subject to correction, what I understand is this clause 4.
Logically.
It says it finally upheld the Act of 15.
Also, my lord, that is why, my lord, if your lordships, my lord, would oblige me, and please have page 377 for a moment, my lord. That's where the lordships define, my lord. Or paragraph 2, my lord.
Yes.
In these appeals. And of course, my lord, I'll take your lordships, my lord, in detail through the judgment, including those paragraphs which ultimately led to that conclusion. In these appeals, the appellants have assailed the legality and correctness of the order dated 30/10/2014 passed by the Division Bench of the Guwahati High Court in writ petition number 5789 of 2005, whereby the High Court, by allowing the writ petition, struck down the Assam Rural Health Regulatory Authority Act 2004. Hereinafter, my lord, the emphasis lays here, my lord, in my humble submission, referred to as the Assam Act or the State Act for the sake of brevity, which was enacted by the Assam State Legislature. In that context, if your lordship will, my lord, kindly oblige me and please have page 506, left-hand side bottom, my lord.
I'm just trying to correlate between your prayers and the directions of the apex.
Yes. Well, in my humble submission, my lord.
The apex court upheld the 2015 to say that it's not in conflict with the Indian Medical Council Act.
It has removed the basis of the judge.
It doesn't deal with community health
professional,
which means that you are now treated to be community health professional.
No, with great respect, my lord. If I may, my lord, it's very easy, my lord, on the state, and I'll, my lord, request my learned friend, my lord, to give me that opportunity to, my lord, answer in my own terms. Of course, they can reply. Now, page 513, if your lordships come to the middle.
Yeah.
After having noted, my lord, the 2015 Act is also not in conflict with the IMC Act. Now, the following, my lord, sentence in my humble submission would be important for my purposes. This is because the Central Act, namely IMC Act 1956, does not deal with community health professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam. Now, that is only 2004 Act. There is no other Act, my lord. 2015 Act does not permit, in my humble submission, my lord, community health professionals to practice allopathic. Well, they are reduced as paramedics under the 2015 Act. In my lord, I tell your lordship, my lord, in my humble submission, but the question has often arisen as to what is the effect, my lord, of, my lord, striking down of a legislation. My lord, earlier there was, my lord, two views, my lord. A, that, my lord, if an act is struck down on the ground of lack of legislative competence, my lord, it is void ab initio, as if it has never been enacted by the state legislature or the legislature concerned, my lord, and all consequences and effects of. In case of an act, my lord, which finds itself found in a judgment of the court of clause 2 of Article 13, namely, my lord, it is violative of any of the provisions of Part 3, namely fundamental rights, my lord, it operates from the date of declaration. Or we go back to the 1951 judgment, my lord, the Constitution Bench judgment of the Honorable Supreme Court, and my lord, I will place those paragraphs to, my lord, make an attempt to persuade your lordship, my lord, that really there was no such distinction. My lord, the question was only gone into in context of a my lord, pre-constitution law, that what would be its effect after coming into force of the constitution. My lord, there are various judgments, including my lord, the
We can't complete.
yes. My lord.
So what we try
My lord, what I have done, if your lordships permit me, my lord,
is that you were allowed to be practicing the earlier act as what was the terminology?
terminology used was rural health practitioners permitting allopathic my lord, medicine only in rural area.
Then with the parameters, perhaps.
Yes, my lord. And subject to a lot of restrictions, my lord. I tell you a lot, my lord. No invasive surgery, my lord, no other diagnosis, only, my lord, a restricted, my lord, prescription of medicines which are permitted to be prescribed under the rules framed by the state, my lord. But the issue, therefore, my lord, in my humble and respectful submission that arises for your lordship's consideration, my lord, I've tried to, my lord, put it R3.
As on date, you are covered by 2015.
2015, I must tell your lordship, my lord, we are in, my lord, contractual service of the state at a very meagerly, my lord, amount of, my lord, roughly not exceeding 30,000 rupees a month. My lord, the questions, my lord, I understand, my lord, your lordship's predicament, and my lord, your lordship have to rise, but I'll just, my lord, point the questions, my lord, so that your lordship can, your lordship's permit, my lord, I have a short note on what, my lord, I propose to place for your lordship's kind consideration. My lord, it is.
What is your status of employment now?
We are continuing. What they did was, my lord, I'm so sorry, my lord. Status, one line answer has to be that I'm continuing on contractual basis as a community health professional. But what had happened was, my lord, we got diplomas as rural health practitioners. My lord, after the judgment, they issued notice to us, which is, my lord, subject matter of challenge, saying that you come and deposit your registration goes, though there was no such relief, my lord, and we were made to be reckoned as community health professional under the 2015 Act.
It doesn't permit you allopathic practice.
No, my lord. I'll take your lordship to both the, my lord, provisions. My lord, that is, my lord, if I may say so, my lord, like a midwife or somebody, my lord, who's a paramedic, who, my lord, opens up, my lord, the oxygen cylinder and all that, my lord. I'll take your lordship to the provisions in detail. The real question would be, my lord, if I'm just permitted, my lord, 3 or 4 sentences, that, my lord, is it, my lord, that one who has been conferred a particular qualification as prescribed under a statute while it was in force, does that person get deprived of that qualification and the right to continue on basis of that qualification in view of, my lord, a statute having been declared as unconstitutional? That's the first question that will call for your lordship's kind consideration. The second issue is, my lord, that in terms of the judgment of the Supreme Court, my lord, how would the court read the, my lord, tracking down of the 2004 Act? Will it be prospective? Does it save, my lord? If it, in my humble submission, saves all those, my lord, qualifications which were expired, that's 25-4. Of course, it's a matter of submission, argument, or debate, my lord, before your lordship. And third important is, my lord, that, my lord, in like, my lord, an act of court will not prejudice anybody, my lord. I wish to, my lord, make an attempt to persuade your lordship to an act of legislature of a state will also not, my lord, prejudice a citizen who has acted bona fide on basis of the act of the state, on application of the state, and in service of the state.
As it existed then.
As it existed. I can understand for future operations, correct. I can come before your lordships and say that permit me or grant me, my lord, admission for the diploma course, my lord. But it can't end, my lord. Coupled with, my lord, I also beg to invoke the principle of, my lord, a legitimate expectation during the period during which, my lord, the act was in operation, and promissory estoppel. Also, I'll show, my lord, how the state was bound. But unfortunately, I don't know why, and I cannot spell out the reason. Though the state came out whole folk in support of, my lord, the petitioners before the Honorable Supreme Court, and I've annexed that affidavit, my lord, before your lordship, my lord, explaining why they came out with the 2015 Act, my lord, which according to me, my lord, was a kind of an immediate, my lord, knee-jerk reaction, if I may use that expression, for the purpose of saving these degrees. But they, my lord, came out in support, my lord, by filing an affidavit is a solemn declaration before the Honorable Supreme Court. I'll place that for your lordship. And therefore, from that as well as other correspondence flows, my lord, the aspect of legitimate expectation and promissory. These are the areas, my lord, I've just indicated where I wish to make my submissions for your lordship's kind consideration. Lord, I have a list of authorities subject-wise on each of the, my lord, with paragraph numbers, my lord, bound as your lordship would, my lord, permit me either to place it today or any day, my lord, that may be.
Pleadings are otherwise.
Pleadings are complete, my lord. They were directed to file by an order of January. Of course, they were given certain time, but beyond that time they filed it. I'm not raising any grievance. I filed my rejoinder.
You are basically affected by the notice, some notice they have
issued. By the notice that I have issued, which, my lord, downgrades me. My lord, say for example, my lord, your lordship may, my lord, may I only give one small example. My lord, suppose there was, my lord, an act which penalized an offense, or penalized an act, my lord. And while the act was in force, a man was, my lord, charged with convicted and undergoes, my lord, the punishment. So what happens when the act is struck down by? But it can't be, my lord, it remains on the statute book, my lord. Your lordships are well aware of those principles, my lord. When an act is struck down either on the ground of it falling foul of clause 2 of Article 13 or on the ground of lack of legislative competence. Only thing is, my lord, as my lord, the 3 or 4 constitution bench decisions have said that it becomes inoperative for the future. My lord, say for example, my lord, notwithstanding, my lord, if situation arose where certain appointments, my lord, were made by, my lord, a, my lord, state which comes under the jurisdiction of your lordship, my lord, state of Manipur, or in the year 2004, there were, my lord, certain posts which were created, which were theirs of, my lord, parliamentary secretaries. The act was struck down on the ground that, my lord, the certain provisions of the constitution do not permit the state legislature to create positions as such. My lord, 2012 Act was enacted, which was in peri materia on the same line. But comes the decision of the, my lord, Supreme Court, and in 2018, my lord, there is a repeal act, my lord, which is enacted by the state of Manipur, repealing the 2012 Act, but saving the act. That was challenged. Now, that was considered by, my lord, 2 of the honorable judges who have rendered the judgment here in our case, my lord, were part of that bench, my lord. A 3 honorable judges bench came to the conclusion that you can't wipe out all the acts, my lord. Suppose, my lord, that parliamentary secretary had, my lord, passed an order, a punishment, or, my lord, grant of, my lord, some privilege.
But saving.
Well, of course, I must tell your lordship that there is one decision which says that per se clause 6 of the General Clauses Act may not apply in cases where, my lord, an act is struck down. But, my lord, in a different way, I will place judgment where the analogy is applied. It's a pure, my lord, question of law in my humble opinion.
You can furnish your list of cases or judgments, whatever you want.
Yes, my lord, we have it ready, my lord.
But we'll have to continue.
Whenever it's convenient, your lordship, my lord. It will take some time, my lord, I may indicate, my lord.
Yes. Give it some time.
Huh? No, no. Compile it. And please give it to the learned government leader. Well, I was only wondering, subject to your lordship's convenience, my lord, whether it will be. I believe, my lord, your lordships have a relatively smaller summer vacation, or, my lord, as we say, my lord, now in the Supreme Court, my lord, as partial court working days, my lord. But, my lord, would it be your lordship's pleasure to have it before or after, my lord? I am entirely.
Actually, well, if we can have it after vacation, then we can perhaps go for a little longer hearing. If it's a day.
I'm in your office.
But before vacations, I think the earliest we can squeeze it would be maybe around 19th or 24th, but that's the last week. So I can't
My lord, I will not, my lord, trouble your
I
lordship,
can't
my lord, having.
tell you that because all these days probably will be declared as a miscellaneous day, the last week.
I've told your lordship. Well, then would it be your lordship's pleasure to consider, my lord, if I may, my lord, indicate
Yes.
the week, my lord, where it can start on a Tuesday. So in case it is spilled over,
Yes.
my lord, that week itself on a.
That we can apply. Huh? Like,
But the 22nd is a Tuesday.
Right.
And 29th is a Tuesday. My lord,
You-
whichever is convenient to the learned government leader, my lord. I'll understand your lordship's.
Yes, my lord, any day.
if it's convenient for you on 29th, we can bring it on 29th.
No, I'll make it convenient, my lord. It's a pleasure to be before your lordship.
We have it on 29th, and 31st.
Lordship, it can.
And then if the government can complete their reply, we can finish off that
That's
week
correct.
by 8th or 7th.
Lordship. Would it be your lordship's pleasure to indicate, my lord, it may come up little high so that on the hearing day or treat it as heard in part, my lord?
Yes, yes. We'll treat it as a part-heard matter so that it will
Very
be
good.
listed higher up. It's
My lord, may I have the liberty of, my lord, I have put in brief submissions. These are the latest one. And, my lord, the list along with the compilation is given. So what I've done is, my lord, I have tabulated with paragraph number. But there may be something extra, my lord. My learned friend will not invoke the principle of promissory estoppel because as you keep on reading, my lord, you find some more paragraph relevant, my lord. Subject to that, my lord, the compilation is also handed over to my learned friend. It's placed before your lordship. No? Just give him that note also. Give you the list of the yes, in the note. No, I'm so sorry. No. I only hope I've given the right note because there also, my lord, I've tried to improve, my lord. If your lordship don't mind, my lord.
There's no promissory estoppel on this side. Correct it anytime you want. Doesn't matter. Or if you can verify it and you can share it.
No. In a moment. Well, I do it right now. But
Your
probably if your lordships don't, my lord, oblige me and don't mind, it will bear today's yesterday's date, 4th of June 2025. The lordships can only oblige me.
4th of June.
Yes, sir. That's the correct one. I tell your lordship, I've changed the sequence, my lord. What had come was that the alternative prayer had come in between. That will perhaps, my lord, I must be fair to your lordship, take out, my lord, the thrust of my submissions on merits on the first part of the matter. That's the only change that I've made, and my lord, I've included 2 new paragraphs.
The charm on the other side is that you can modify or improve on your
My lord,
argument.
it's always a learning process, my lord, and as we, my lord, get new ideas.
Perhaps we don't have the liberty. Once we dictate, that's the end of it.
Yes.
So we'll have it on
29th, as your lordship indicated. Big pleasure, my lord.
Mr. Your Mr.
Raval, Harin Raval.
Kenya Council, assisted by Mr.
Adil Ahmed and Mr. Majumdar, who's on record.
Adil Ahmed and Mr. For help.
Yes.
The Eternal Senior Council to open his arguments. The argument remaining inclusive, of time. Matter being as agreed to, the matter be listed for further hearing on 29th of July, which they think to rely.
I have already done it. 2 minutes. 2, 3 authorities.
Yes. The additional.